just a copy of the statute, the open meeting law statute.
Great. Where are
But
you
she said that
talking
if we
from,
can't make this
Ryan?
happen right now, we can get it to you guys after the hearing today as well.
Okay. All right. I think they're taking care of it right now. It should be okay.
Awesome.
She said they can fax it for us.
Oh, okay, cool. That's great.
Are we good, or do we need?
I think
I think so.
I think we're good. I think we're good.
Do you want me to bring a copy to them?
At this point, I'm on the statute.
Right.
And then just letting them know. I don't know.
I don't know what fax is going to. Let me find out.
Well, she said she was getting somebody's.
Yeah, I don't think they're like us where like you can run something down to us and be like, hey, make 20 copies of this.
No, we just need to get one, and then they can make copies. But
But who could make copies? Like, is LCB up there? In their
that's
own
what they're trying to
building?
find out, if there's somebody that can do that. But then Sophia said it's not.
Ryan, I have a fax number that you can send those to.
Go ahead.
Okay, 775
Okay.
684
Mm-hmm.
6988.
Okay, cool. They're
All
on their
right.
way.
Thank you.
Thank you.
You fine? What?
The clerk's going to confirm all the clinical claims she's got, and I'll pick them up on the way back from her.
Okay.
Richard, did you find you guys?
Ryan, as soon as we confirm that we have that fax, I'll go ahead and let you start our training. Or start our meetings to start the training.
Okay, great.
Thanks.
Everyone else is coming for the main meeting.
Yeah. All right, Ryan, we haven't received the facts yet, but I'm going to go ahead and start the meeting because I don't want us running into our timeline that we have for the speakers later. So I'm going to call to order this meeting. It's September 26, 2017, and we're here at noon in both Las Vegas and Carson City for the public meeting on Child Support Guidelines Committee. I'm going to do roll call. Please announce if you are here. Kathleen Baker.
Carrie Cordisco on behalf of Kathleen Baker.
Karen Cliff.
Present.
Ellen Cresilius.
Present.
Senator Farley. Assemblyman Fumo. Push your button. Aren't you there?
Here.
Judge Hoskin.
Yes.
Nova Murray. Not present. Assemblyman Pickard.
Here.
Judge Robb. Not present. Senator Roberson. Not present. Joseph Sanford. Not present. Judge Shirley. Not present. Justice Stiglich. Not present. Kim Surratt, I'm present. And Don Thorne.
Present.
We have 1, 2, 3, 4, 5, 6, 7, 8. We have exactly a quorum. Going to go to the next item on our agenda, which is Nevada Open Meeting Law Tutorial by Deputy Attorney General Ryan Sunga, and whoever you have with you, Ryan.
I have Sophia. I'd like to introduce you all to Sophia Long from the Attorney General's office. I brought her down to do the presentation because she is actually in the boards and commissions unit of the Attorney General's office, so all she does is open meeting law, so she's
And a little more.
What's that?
And a little more.
Okay, way more than me. Way more open meeting law than me. So, and not only that, but she's done presentations to this to her boards and commissions that she represents, and she already had a PowerPoint all ready to go, so I didn't have to reinvent the wheel. And I'll just turn it over to her.
Thank you. Good afternoon. Again, I'm Sophia Long, Deputy Attorney General, and I will be speaking on the very exciting topic of open meeting law. As I go through this presentation, if you have any questions, just feel free to stop me, and I'll be happy to answer any of your questions at that time. So I know down here, I'm not going to go page by page through the PowerPoint presentation, but I know down here we do actually have a physical copy of the PowerPoint presentation. Okay. So on the first page, it talks about open meeting law. And on the first page, it also, I mean, I'm sure a lot of questions that you have is why do, for example, this committee has to abide by the open meeting law, what constitutes a meeting, you know, what you can and can't talk about. So, so on the first page, it discusses the purpose of the open meeting law. And it's basically for boards and commissions like this to have transparency when you discuss anything under your jurisdiction. So the public is on notice as far as what this board does, the decisions that it's going to make. So that's why, you know, we get these lovely agendas that we have to produce before a meeting. So the second thing is who it applies to, because I know, you know, for example, it really doesn't apply to the legislature because it's specifically exempt from open meeting law. But what it does apply to, and I'll just read it directly from the PowerPoint, it says public bodies working on behalf of Nevada citizens must conform to statutory requirements in open meetings under an agenda that provides full notice and disclosure of discussion topics and any possible action. So basically it applies to public bodies that are pretty much doing things for the benefit of Nevada citizens. And, again, I know it doesn't apply to legislature because there are some specific exceptions to some bodies. For example, Judicial College, I think the Tax Commission is specifically exempt from the open meeting law. But otherwise, unless a body is specifically exempt, open meeting law does apply. So it'll also apply to any subcommittees that a public body has appointed as well. So I think this is a subcommittee, is that correct?
No, this is the committee.
Oh, okay, sorry. So it applies to this committee just because it's a committee. So then it talks about, so then the open meeting law also addresses basically what constitutes a meeting. Because if the members or committee members are discussing something that they have jurisdiction over, that is considered a meeting. So then that meeting, of course, would be subject to the open meeting law. And then, of course, that would make the meeting subject to specific notice requirements. Any questions so far?
Yeah, how far does that extend? If two of us are having a conversation about child support, are we violating?
Sure. I actually will get to that. Good question. And I'll tell you when a violation occurs, and I'll also get to when a violation occurs, how you can remedy it or correct it, what's the best way to do so. So, and again, there are some exceptions to a meeting. And one exception is if the committee is at, for example, a social gathering, and they're not discussing anything within their jurisdiction, it's not considered a meeting. Just because you have a quorum present, does it automatically make it a meeting? Another thing is if the committee members are discussing with their attorney any potential or existing litigation, that's, of course, not considered a meeting either. So the meeting actually first, of course, starts kind of behind the scenes, and that's your meeting notice and agenda. So what we'll do is actually take a look at your agenda, because the agenda actually dictates to basically what the committee can discuss and kind of some guidelines as far as how the meeting is going to be conducted. So first of all, the first thing on the agenda is, of course, if you want the public to attend or put the public on notice that there is going to be a meeting, that there has to be a time, place, and location of the meeting. So you see that specifically on your agenda. So do you know what happens if, for example, on your agenda, it says, if we're down here in Las Vegas, that the meeting will be held in this room 4401, but 4401 is not available? What can you do?
Cancel the meeting?
Okay, so someone said cancel the meeting. So what actually happens is, of course, there's a little bit of leeway. So 4401 is not available. And as you stepped off the elevators here, there's a few other rooms that are here. So for a room adjacent, even maybe a room downstairs, something that's not too inconvenient for the public to get to, you can still hold the meeting in another room. However, if it's something that inconveniences the public, for example, if they have to leave the building, if they have to go across the street, if they have to get in their car and drive somewhere to go to another meeting, or to another location for the meeting, then that's probably when you want to consider to not hold the meeting. But anything that's reasonable, even on the first floor, that can accommodate everyone. If it's something where the public could still get to without being really inconvenienced, you can still hold the meeting. So another thing that happens is, what if the date is accidentally scheduled wrong, and on the agenda it says September 28th, 2017 instead of September 26th, then what do you do?
Cancel.
Right, so the default answer seems to be to always ask your attorney, the Deputy Attorney General. But if it's something where it seems reasonable that the public would think that the actual meeting was going to be held September 28th instead of 26th, it probably is best to cancel it. But for example, if it said September 26th, 2016, That's kind of a different story. Again, if you confer with your Deputy Attorney General, it depends. Sometimes you can hold the meeting because it would seem unreasonable, of course, that it's clearly a mistake. But your Deputy Attorney General may advise different. But if there's a big mistake like that, just always confer with your board counsel, I guess, or your commission counsel. So another thing is, I noticed on your agenda, it says, if someone's unable to attend in person, a teleconference will be available. And then there's the numbers. What do you do if the telephone lines go out?
We actually had that happen last meeting.
Okay, so what did you do?
We stopped the meeting until we could get it working again.
Okay. So technically, pursuant to NRS 241, your only obligation is to provide a room where the public can attend. So if your telephone line goes out and there's only people of the public on the telephone line, you can still continue the meeting. Because again, I mean, you can note it on the record, but again, your only obligation is to provide for people to be here in person. So moving along through your agenda, the next thing you have is sites will be connected by video conference and available for view on the legislature's website. So another requirement in order to comply with open meeting law, and it really just deals with the commission members, is that everybody needs to be able to at least hear everybody in real time. So you can't have telephonic conferences with all your commission members, but we had a situation where, similar to this, where you're video conferencing north and south, and then the video went out, the video feed went out, I guess. And one of the commission members was just texting their conversations up to the rest of the body up north. So that's not in compliance with open meeting law, because you do need to, in real time, at least hear each other, hear the votes, hear the conversation, hear the discussion. Any questions? No? Okay. So I'm just gonna.
I've got a question. Does that mean if the video goes out, but we still have audio, that you're saying we're in compliance?
Yes.
Okay, thank you.
So again, the open meeting law only requires that all the commission members are able to hear each other in real time. To see each other would be great, but to hear each other is just the requirement. Okay, so moving along. So when we get to basically the body of the agenda, one of the requirements of open meeting law is that when you draft your agenda, it says that the agenda has to consist of a clear and complete statement of the topics scheduled to be considered. So in drafting the topics of your agenda, what you really want to do is just make sure that, again, on each agenda topic, you ensure that if a member of the public were to read this, would they know exactly what the commission would be discussing for each topic. So that allows me as a member of the public, when I look at your agenda, I can say, well, I'm interested in this topic or I'm not, or I'm interested in their vote and where they're going with this, and I may want to provide opinion or public comment or anything. So if it doesn't, so that's the basic requirement of the clear and concise statement on your agenda. And actually, I reviewed your agenda and it looks good. So the next thing is, if we look at agenda item 4, and it says approval of meeting minutes, and below it says for possible action. So we know that for possible action means that it's an item that the commission can vote on. So if it does not say for possible action, but the commission wants to take a vote, then what happens? That's right. Yeah, you're precluded from voting. So if it's something that the commission did want to make to make a decision on, you just have to table it to your next meeting, and then at that time you can just put for possible action and make that vote. And again, because it says for possible action on an agenda item, it doesn't mean you have to vote. So if it doesn't say it, you can't vote. But if it does say it, you don't have to. So another thing is, when we're looking at the agenda and the topics, the committee should stay on topic per agenda item, because otherwise, again, when the commission starts to birdwalk into other things or into other general topics or starts discussing other things, again, looking at the viewpoint of the public, they were not on notice that this would be, something else would be discussed. So that's why it's really important that when you get to a specific agenda item, that you stay on topic for that item.
Can we combine like 4, 6, and 8 and talk about them at the same time?
Good. That is a good question. And as a matter of fact, you can, as long as you put your public on notice, which on your agenda you do. So if you look at page 1 where it says stacked agenda, it says, unless otherwise stated, items may be taken out of order, presented on the agenda at the discretion of the chair. Items may also be combined for consideration, pulled, or removed from the agenda at any time. So the public's on notice that, as you said, that combined, and as a matter of fact, if you get to an agenda item and the committee is just not ready to discuss it, they need more information or something, you can even not talk about it at that time. You can just move on. And as a matter of fact, the way that the meeting is ran and whether to combine agenda items or whether to pull agenda items from the meeting is usually at the chair's discretion. So we know that the chairperson runs the meeting, so the chairperson usually is the one that makes that decision as far as how the meetings, the agendas or the items on the agenda would be discussed. Okay. So again, moving right along, if you look on the last page of your agenda, another requirement that the open meeting law has is that to accommodate persons with disabilities to the best of your ability. So that's why on the agenda, you're requested to notify someone if you need some sort of accommodation. So, for example, a lot of times, in some of my other meetings, we get people who are deaf that come, so they would request an interpreter. And if an interpreter charges, it is not a cost that you can pass on. So the committee will just have to bear it. So, and just a small point that I notice is not on your agenda, but that should be, is there's a requirement that if someone wanted to obtain copies of either the agenda or any sort of the meeting packet or any documents that the committee will go over, that a name of a person and their contact information should be listed. So just for next time, just add it to your agenda.
That was my fault.
It's okay, just add it. So, so specifically then, of course, there are some other notice requirements that your staff will actually take care of, which is basically that it has to be posted and then posted at certain locations 3 business days prior to you holding the meeting and posted on the website, but that should all be taken care of by your staff. So, does anybody have any questions on the agenda itself? Okay. So
Is
then,
it that, I've got
sure.
a question. On
Sure.
the copies that they can request, there's the agenda, but would it be anything else that we discussed during the meeting? For example, we've got posted on the website the guideline review that we're referencing constantly in this agenda. Are we to provide a copy of that to the public?
Yes. So any documents that the committee looks at a meeting is public information, and it should be provided if somebody requests it and on your website.
So the website's not sufficient, though. So if they want a hard copy, you have to provide a hard copy.
Yes.
Okay. Okay.
And also, and with that said, just be careful of sensitive information. You can redact it and provide a hard copy or put it on your website.
All right, thank you.
So you also have it's required that you have time for public comment. And there's two ways to do public comment, but the easiest way, I believe, is what you have on your agenda and what most public bodies will do. And that's basically providing a time allowed for public comment at the beginning of the meeting and at the end of the meeting. But that also does not preclude you if you want to provide public comment during an agenda item or any other times during the meeting. So the requirement is just 2 basic periods of public comment at the beginning and at the end. And the beginning is before any action is taken, and the end is after all action is taken. So when someone provides public comment, normally that period is for the public to comment on anything that they wish, as long as it's basically under this committee's jurisdiction. So they can't come here and just complain about, for example, the medical board or something else. But there are also some restrictions that the committee has placed on public comment. And so 3 of them are specifically that the committee cannot stop comment based on viewpoint of a speaker. The committee cannot stop comment based upon belief that defamation is occurring, or the committee cannot stop comment because a speaker is being critical of a public official. But what I see that you have done, that a lot of committees do as well, is that you can restrict public comment to time, place, and manner. So if normally people who come and do public comment, if you give them all day, they'll talk all day. So as long as you have on your agenda, and it pretty much is made aware that that you can limit public comment, and I notice that yours is limited to 3 minutes. And after 3 minutes, you can just stop them in the middle of a sentence or anything. 3 minutes is 3 minutes. And another is just repetitious comments. So you can stop that as well. So a big one, and it usually happens during public comment, but it can happen during any time during the meeting, that if someone is being disruptive and to the point where they are pretty much preventing the meeting from happening, from continuing, then you have the ability to pretty much remove that person from the room. But otherwise, again, if someone is just being critical or anything like that, that they have the right to be in the room. So pretty much the line is where the committee just cannot continue its business if this person is still here. So now that we're talking about a meeting and that we're all here for a meeting, and so there's a question earlier about what if outside of a meeting 2 of the committee members talk. So a meeting, again, is usually a quorum. And today, I think someone said the minimum was 8 for a quorum. Okay, so clearly if you have 8 people discussing something under your jurisdiction, that's a quorum and it should be at a meeting. So what if you have 7 people or 6 people or 5, technically, it's not a violation of open meeting. However, what usually happens is 2 or 3 members will talk, and then 1 member will talk to a 4th member, and then the 4th member will talk to the 5th member. And then so that's considered a walking quorum. So, like I said initially, 2 4, 5 is not a quorum, so it's not a violation of open meeting. But the minute that the 5th person goes talk to the 6th, 7th, or 8th person, then that becomes a violation, regardless of all 8 people were in one room and discussing it at the same time. As long as you're discussing the same topic and you're kind of walking it down the line, do you understand? Because it's starting to become a quorum, and that's in violation of open meeting. Any questions?
Yeah, I don't think you answered my question.
Okay.
If, say, 2 of us, district attorney and I are in another meeting and we start chatting about child support or maybe the direction we think this ought to go, sorry to throw you under the bus, is that, from what I heard from you, that's not a meeting, so it's not a quorum, so it's not a violation.
Correct.
Okay, then I did get it.
But my caution is,
Oh, great.
it can become if you talk to someone else and then someone else talks to someone else and someone else talks to someone else on the committee, then that's what's considered a walking quorum. So you're moving it along.
Well, I'm trying to fashion something in my head of an ability to control that. Is there a control to oversee that? Because, say there's 3 of us. The 3 of us sitting here have this conversation outside of this committee, and one of us talks to somebody else, and I don't know when it's gotten to 8. So how do we not violate, I guess, is what I'm trying to ask.
Just to not talk about it outside of a meeting.
All right, I'll take that.
So I will tell you too, you're human and it does happen. Sometimes we just, as board counsel, we just go, okay, And so next I'll just actually talk about when violations do occur and what happens. So when violations occur of the open meeting law, the quick and easy answer is to remedy. So for example, on the agenda, if you did a vote on an item that was a non-action item, then at the next meeting, you would just correct it. And that's basically acknowledging that you did a vote and that vote was void because it was in violation of open meeting, and just do the vote correctly. Another thing is, and I hate saying this, but a violation is technically not a violation until someone complains. So there's also a statute of limitation to someone complaining. And it's usually, it's either 60 days or 120 days for certain violations. So if you're beyond basically the 60-day limit and someone complains, then technically, I guess, there's nothing that can be done. So if someone complains, it usually comes to our office, the Attorney General's office, and if they're outside of the statute of limitation, just like when you file, a lawsuit, if you're outside the statute of limitation, it is what it is. Committee members are, of course, for non-willful violation, there is immunity. For willful violations, which we don't see, of course, that often, our office, I don't know, it just gets referred to our office and then they do what they do. I personally have never, I've been with the AG's office for almost 8 years and doing this for almost 8 years. I've never seen a willful violation be prosecuted, so. So the last thing is, again, the chairperson is responsible for basically running the meeting, moving the meeting along. If the chairperson says, it's time to move to the next agenda item, then we all just move to the next agenda item. The chairperson also should see the agenda prior to it being posted and basically approving it just because, you're responsible basically for running the meeting as well. So you kind of have a heads up as far as what's on it and what's going on. And you also have the right to take things off the agenda at that time as well, or add things. So I think...
Wait, let's talk about that add things. Because I thought at the last meeting, we had to have set what would be on that agenda for it to even be on that agenda. So
it does not. You can add things. I noticed on your agenda, and some of my other committees do it as well, is you do have an agenda item that says approve future agenda items. It really is just so everybody's on the same page. But before the agenda is posted, the chairperson can add more things to the agenda. And as a matter of fact, if the board member or if the committee members believe that something should be discussed, you can request that it goes on the agenda as well. So you're not locked into what you put on it last time.
good information. Thank you.
Sure.
I'm sorry, just going back to the issue we were speaking about previously with respect to speaking about some of these issues with other commission members. Do you have a recommendation regarding us speaking about these issues with non-commission members? Because we do get a lot of, or at least I do, how's it going? What are you leaning towards? Thoughts on that?
The only thing I would recommend is if you've discussed something openly, so an agenda topic that you've already discussed, to talk about it with non-commission members. Otherwise, what happens is people who are not on the commission, they see you as on the commission. So when you say things to them, they may take it as this is what the whole committee has decided or determined already, or is going in this direction. So.
Thank you.
Sophia, I have a question for you. With regard to upcoming agendas, is it the chairperson's agenda in terms of what goes on it, or is it up to her to decide ultimately what goes on it, or can she make it more of a democracy and discuss the next agenda at this meeting today?
It is whatever the chairperson's pleasure. So if she wants, so again, if the committee members want to send her things that they believe should be on the agenda, she could either veto it or put it on.
Okay.
So I think that is my brief summary of the open meeting law. I hope it was helpful. And again, if you cannot sleep at night, NRS 241 I provided to you, it goes into specific detail about what should be on the agenda, about violations, and then who, of course, takes up the complaint for those violations. And it also goes into detail on some things that I don't believe that this committee really that touches this committee. For example, it talks about if there's administrative hearings, or if you need to talk about someone's mental state, right? So I don't think that's the purpose of this committee.
Issue. Yeah.
So unless you have any other questions,
Sophia,
I believe that. Yes.
Sorry. So we received your fax, but it was so many pages long that the building only made us one copy. So can we state on the record that we will place this on the website for access for the public, and then email it to each of the commission members?
Sure, that's fine.
Okay. And then I had found online from the AG's office the Nevada Open Meeting Law Manual from January 2016. Do you recommend that as a good resource for this committee too?
Definitely. That goes into, again, painstaking detail regarding the open meeting law. So if you have free time, feel free to peruse that manual.
And if you don't, just call me.
I read it.
Okay.
So, and I have one more question. On our agenda, we have that limited copies of the agenda will be available at the meeting locations. Is that a safe statement to make, or should we not be saying we will only have limited copies? Because aren't we required to have them for everybody if they appear?
Yes and no, because it just depends on what's reasonable for the committee. So for example, I do have smaller committees and smaller boards that have limited resources, so they're not able to provide more than, for example, 3 copies to the public. So just whatever the committee can do.
Okay. Okay. Okay, anybody else have any questions? Sophia, we really appreciate your time. Thank you.
Thank you. Oh, and my contact information is also on the PowerPoint. So if you have any questions, you can either refer to Mr. Songo or myself. Okay. All right. Thank you.
Thanks, Sophia.
Ryan, did you want to add anything to the end before we change agenda items?
No, not at this point.
Okay.
I just realized, though, that we didn't do public comment
We have it on the agenda for after this.
after this. Okay,
Yeah, we have it as agenda item number 3.
great.
Okay, thank you, Sophia. We appreciate you. We will move on to agenda item number 3, which is public comment. At this time, anybody with the public that would like to make comment may do so. The time limit is 3 minutes per person. Do we have anybody in Las Vegas that would like to give public comment? Seeing none, I believe, since I'm really only looking at the committee members. Do we have anybody in Carson City that would like to give public comment? Seeing none, we close that agenda item and move on to the next agenda item, which is number 4, approval of meeting minutes from the September 8th, 2017 meeting. Has the committee obtained a copy of those minutes? And I know a copy of those minutes.
We have them here.
Okay.
We do have them here, and I'll move to adopt.
Okay.
If I could clarify, there's, in the minutes, it does state that I recommend that our state move to the income share model. I don't recall stating that. If I did, it was a gross misstatement, but at least for now. I'm not sure how that's rectified.
Do you know where in the minutes that is located so we can reference it specifically? Yeah. Page 9, that's what I just heard.
So page 9.
Yeah, I think, let me see here. The issue is whether Mr. Pickard would entertain amending his motion to approve the minutes with that change or not. Mr. Pickard, are you willing to do so?
I'm sure amenable. Let's find out what the change needs to be, though.
I think it's prior to page 9. It's page 3 of 13, paragraph 4.
The second to last sentence that states Ms. Cliff recommended Nevada move to an income share model which will lower the amount of possible deviations. That statement?
Yes, please. Yes.
Just that statement. All right, I'll amend the motion then to adopt, except for the one sentence. Ms. Cliff recommended Nevada move to an income share model, which will lower the amount of possible deviations.
We have a motion to accept the minutes with, a redaction of that one sentence by Assemblyman Pickard. Do we have a second?
Second.
Is that Judge Hoskin? I can't see. I'm
Judge
just
Hoskin
going
for
off
the
of
record.
voices.
Thank you.
All right. Judge Hoskin is a second. All in favor, say aye.
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 Anybody opposed? Motion passes. Okay, we are running a little bit ahead of schedule. Do we, next agenda item is number 5, which is report from Jim Fleming, North Dakota's Child Support Director in regards to child support calculation model in North Dakota. Let me determine from staff if we think he's available. He may be on the phone. Mr. Fleming, are you listening to us? No answer. Okay. So,
If he's not there, Kim, Mr. Wattoon is here if we want to jump ahead a little.
okay, let me check real quick whether or not our individual from Minnesota is available, who is the next item. What's her name? Because it's not on the agenda.
I'm here, Tara Borton.
Tara Borton. Awesome. Good. We'll move on to you next, which is agenda item number 6. Report from Minnesota regarding their child support calculation model. And ma'am, you are welcome to go ahead and give us your report.
Perfect. First of all, can you guys hear me? I was getting a little bit of fuzziness on my line, so I want to make sure I'm clear.
You're very clear in Carson City, Las Vegas. Is she clear?
Yes.
Perfect. So I'm Tara Borton. My role here at the Department of Human Services in Minnesota is as a staff attorney and a legislative liaison. And I'm also working on administrating a task force that Minnesota has that's very like your committee that you have there in Nevada. So I was not around when our guidelines changed in 2007, but I am going to try and give you a little bit of a history of what our guidelines used to be and then move on to what they are now, and highlight some of the differences that there were in our pre-2007 guidelines and then the guidelines we have now, and maybe discuss a little bit some of the pain points that we have found on ours. So does anyone have any questions about that? Good. So way back in 1984, Minnesota was one of only 3 states that actually had statewide guidelines. And folks who have been here might remember that way back then is when the OCSE made it mandatory that the states get on board. So Minnesota was one of them that was on board before it became federally mandated. Way back then, our guidelines were based on a percentage of obligor's net income. The percentage was a sliding scale based on income and number of children. So, for example, it was 16% for a very low-income person with 1 child, and that went all the way up to 50% for someone who had $5,000 a month income and 7 children. And then the statute gave some leeway for above and below those numbers. Our net income at the time included deductions for taxes, union dues, pensions, health insurance, and other child support. At the time, there was no adjustment for parenting time. This went for a while where there was no adjustment, and then since there wasn't one in statute, the judiciary kind of made one up, and that became a little bit messy. The common law that came out of that used custody as a threshold. So some parents with no, quote, custody, but a lot of parenting time didn't benefit from that judicial parenting expense adjustment. Child care now, as then also, always was separated out from the guidelines. So even way back in 1984, we had taken child support out of our basic guidelines. That has always been based on the actual child support amount and has not been built directly into our base support guidelines. And that's prorated between the parents based on income. Medical at the time was included in that base support, but it was allowed as an income deduction for the NC, for the non-custodial parent if they had an expense. So that's kind of the snapshot of what we had from 1984 all the way through 2007, and I'm just going to pause in case anyone has any questions that I hope I will be able to answer because I wasn't around. Super. So back in 2007, the legislature finally made a change, and that was something that they'd been talking about since 1999. So it took 8 years, really. I think the thing actually got changed in 2005. So it was like a 6-year process to actually change the guidelines model. And I'm going to define for you a word because I know that no matter how hard I try, I'm not going to be able to avoid using this term. So the term we use in Minnesota is PICS, and that means Parental Income for Child Support. So if I say that through my presentation, I apologize. It's kind of built into to our language here in child support in Minnesota. So PICS is just the parental income for child support. So it's the amount of income that we're counting from each parent. And if we say combined PICS, that means the parent's total income when you add together the obligor and the obligee's income. So the method that we have now that started in 2007 uses gross income, and I'm just kind of going to go through a 5-step process of how Minnesota gets to our number. So that starts with the determination of income. So we use gross income now, which was a change from previous to 2007, and it uses the income of both parents. We are allowed to impute if there is no income, but the person is able to work. And even though we use gross income, there are a few exclusions and deductions. For example, we exclude certain overtime. We exclude child support that is received. We exclude the income of a spouse or children in the home. Public assistance is excluded. Business expenses can be deducted. Court-ordered support and maintenance can be deducted. And there's a deduction for up to 2 non-joint children living in the home. So if the child is outside of your home, you'd be getting credit for whatever child support you're paying out. If that child is in your home, we use our guidelines amount based on your income to see what deduction you will get for the children that are living in your home that you are caring for. So we basically give a 50% of the guideline support using that parent's income. So if you made $2,000 and you'd have 2 children in your home, you'd go to our guidelines chart, you'd find that number, and you'd get credit for those 2 children. If you have more than 2 children in your house, you only get credit for 2. And I'm going to pause again just for questions if anyone has any.
No, ma'am. I'll interrupt you, too, if we do have a question. I'll let you know when I see a hand.
Perfect. Thank you. So our second step is that we determine the base support. So this is actually a chart that we have. We use that combined PICS, so adding together both parents' income, and we look at a chart. Our numbers, as they are right now, are based off of the USD estimates for the cost of raising children. Minnesota is the only state that uses that as the basis for our guidelines. We exclude both medical and child care. So when we were taking into account those USD guidelines, we pulled those out. And it was adjusted using some of the other methods. So we kind of took those USDA numbers and then we kind of chopped the top and the bottom after comparing them with other economic models. So once you find that amount in Minnesota, you would go to a chart, find the number based on both the parents, and then you prorate it between the parents. So if one parent made $2,000 and one parent made $4,000, the parent who made $2,000 would be responsible for 33%, and the parent who made $4,000 would be responsible for 67% of that amount. Our chart only goes up to $15,000 a month combined income. So if the parents made more than that, you would use that $15,000 a month top, but then you would prorate based on their entire income. After that, we apply a parenting expense adjustment, and I can talk a little bit more about this if there's some questions, but I think I'm going to blow by that a little bit right now because we're actually in the process of implementing a change. and the CLE that I give about that is about 75 minutes long. So we'll blow by that for now. Just know that Minnesota has a method now where we give kind of two broad deductions based on how much you have, but we're going to a different method that gives you credit for each day. After
Can
we
I
give the
interrupt for just a
parenting
second?
expense adjustment, we
Ma'am,
figure out the child
you do
care.
have a question.
Can you hear me okay?
Yes.
Ms. Borton? Just before we get too far past this, if I understand, this is Judge Hoskin for the record, if I understand what you're doing, you're calculating all of these deductions off of gross income before you get to your combined picks, correct?
Well, the combined picks is gross income. So you're adding the two parents' gross incomes together for the combined picks. And that is what you're pulling off of the chart.
Yeah, but you indicated that you give deductions off of gross income for overtime, child support, the other spouse's income, public support. You're giving all those deductions before you come up with combined picks, yes?
Yes, yes.
Okay. And what is the process if there's a disagreement between the parents as to what those numbers are? How do you get to that combined picks number?
So that would all happen in court, and a judge would just decide that. In Minnesota, we have a totally judicial process. Even our expedited process is judicial. So a parent would always have an opportunity for the hearing, and in fact, most of our establishments end up at a hearing, even if they're in an expedited process. So the parents would have an opportunity to bring those arguments to a judge or a magistrate.
So it's a judicial determination as to what deductions are taking off of gross before you get to picks?
Yeah, if there was a conflict, yes.
Okay, thank you.
Yep.
Yeah, Karen Cliff from the Clark County District Attorney's Office. Just to clarify, in obtaining the pick, at what point do you determine the custodial arrangement, or is that even a consideration?
So when we do our pleadings, we would only put in the custodial, well, we wouldn't even call it a custodial arrangement. We're moving away from using that term custody to determine anything with child support. So we would always just determine parenting time. Now that our parenting expense adjustment is changing, it's going to be very critical that those orders have a specific number of nights so that we can get to a number of nights with the schedule. If something comes up in our office where they don't already have it, then they're not going to get credit for that parenting expense adjustment. And obviously, if they're in on paternity, the federal regs and therefore our statutes allow a magistrate to do that, even outside of the district court process, that if the parents agree, they will set that. But otherwise, if there's no order, especially moving forward, they're not going to get credit for that parenting expense adjustment. And it's largely on the parents to get that into court.
Okay, so is the process then that you look at both parties' income, but then there's an offset provided based upon timeshare, but that timeshare has to either be agreed upon or there has to be a court order? Is
That's
that
right.
what I'm hearing?
And moving forward, even the agreement is going to be a little shaky. They're going to have some sort of court-ordered process. But we're kind of working through that right now.
I see. Okay, thank you.
So after we finish with the parenting expense adjustment, we move on to look at the child care and medical expenses. In Minnesota, those are completely separate. Child care, especially here, it's very, very, very important that we take that out. Minnesota has extremely high child care costs. I shared with the folks on the phone in preparation of this the other day that my own child is 3. She's at our local YMCA. And our child care is about, what is it up to, $234 a week or something. And that's a relatively cheap center here in the cities. So for us, for these purposes, it's very, very, very important that we take that child care out, because if it's considered separate, then we know we're getting it right. If it's worked in, then we know that obligors are always overpaying if they're not paying for child care. And we know that an obligee isn't going to be receiving what they need if they have a child in child care, because their order is definitely not going to cover it. So child care and medical are both considered separately, and they're prorated from the PICs. So If child care is $1,200 a month, we're going to split that up based on the share of the income. The same with medical insurance. So there's medical insurance has to be ordered, and then there's also beyond that, uninsured costs are not worked in. I know a lot of states who even maybe do order medical insurance to one party or the other. They just provide $200 or $300 or something in there for those other costs. Minnesota doesn't do that. They're all actual costs. So when a parent goes to the doctor and pays that $35 deductible, they have to submit that expense. Child care gets paid automatically. You don't have to submit it once you have proven it up that's what it is and it's in the order. However, if it changes, it is actual, which means that overpayments sometimes happen. If a parent changes their child to a new center or pulls them out and doesn't tell the other parent, it's based on actual. So there are sometimes overpayments. So there's some give and take there in the way we do it by excluding it. We think that it gets much more correct orders, but it does sometimes cause some accounting problems because it's based on the actual expense every month.
So
and then
isn't
the
it
last thing that we
possible-
do on our orders, so after we now have a base support that we pulled from the guidelines chart, we have a different child care support amount and a different medical support amount. And then we've ordered someone to carry medical insurance. The last thing we do is do our low-income adjustments.
Before
So
you
we have
start
a
low-income
self-support
adjustment,
reserve.
ma'am, we have one more question about the medical from Judge Hoskin.
Yep.
Just in looking at practicalities and given what you've told me is your child care and potentially medical expenses, how often do you have a circumstance where your child care and medical expenses adjustment exceeds your child support calculation?
Frequently when we have young children.
And then what do you do
So
with
you
that?
mean like the base support amount? I'd say it's
Yes.
pretty common that we would have a low base support amount, $200 or something. But if you have an infant in care here, you're looking at, $1,400 for one child. Divvy that up. It would be easy for even a low-income person to have $700 or something in child care. However, if they're on CCAP, if that family is on CCAP, then that would be looked at a little bit differently because then we will look at what their kind of co-payment is for our child care program for public assistance. So there's a little something there for low-income people who have a super high child care cost.
So is child support zeroed out at that point? Is there some kind of another adjustment that you make?
Yeah, if you, here, I can actually get to this next part, and I think that might answer your question a little bit.
Okay.
Because we have a
All right, I'll
self-support reserve, excuse me, that's based on 120% of the federal poverty guideline. So if an obligor only had $1,300 worth of income, we would reduce that. I think it's, what is that now, $1,206. That would get reduced by $1,206. So their obligation gets down to $96. And that medical is the first thing that would get reduced down. Child care would come second, and then it would dip into the base support last. So if you were low enough income to fit into that self-support reserve, that's the order that those obligations would start falling off. It would go medical, then child care, and then get to the base support. Does that answer your question?
I believe so, yes. Thank you.
So the self-support reserve is only one of our low-income adjustments. We also have the minimum order that can take effect if that self-support reserve dips too low, or sometimes if somehow the order comes out to, $10 or $12 or something. Our minimum order is $50 for 1 or 2 kids, $75 for 3 or 4 kids, or $100 for more than 4 kids. And then we do also have a deviation statute that's fairly broad. It's things like income disparities, extraordinary debts, extraordinary financial needs of the child, child's cost of living in a foreign country, that sort of thing can cause a deviation. So that's kind of my quick summary of how we get to the number in Minnesota. The big differences between the pre-2007 and the post-2007 are that after 2007, we're considering the obligee's income. We think this is really important because it acknowledges the contribution of both, and it really acknowledges that the parent with the child in the home is also paying something, even if the money isn't exchanging hands between the parents. It also uses the actual estimates of what children cost to raise, and that's another benefit that we think happened in the changeover. It uses gross income instead of net income, and that does reduce some litigation. I know that there were a few kind of things that can be excluded, but they're few and far between, and for the most part, they're sort of non-controversial. No one can really come into court and argue effectively that the income of the spouse should count because it's clear in the statute that it doesn't. So there's just fewer opportunities for litigation. And there's less opportunity to sort of scam the system by putting money in your 401k and things like that were happening before. We now have that parenting expense adjustment in statute, and as I mentioned, that's actually changing again. So we're going to have a new parenting expense adjustment August 1st of 2018. We take out the medical as well as the child care from that base support amount, so those are more precise orders. And it is recognizing the costs associated with non-joint children in the home. We did not have that before. So you had 7 kids in your home, that was not being considered. And now, even though we're maybe not considering all 7 of them, we're considering 2 of those non-joint children who are in your home. So those are sort of the big differences between pre-2007 and post-2007. We do have some pain points that we've identified in our guidelines where we see some really unreasonable orders, and this is one of the things our task force is looking at. And the biggest one is right above where that self-support reserve kicks in. So we're looking at people who have, $10 to $13 an hour jobs. So once you start hitting that self-support reserve, every dollar above that goes to child support until you hit that number. So if someone is at, let's say, $1,300 and they have a $200 order, they're going to pay $94, and then if they get a $100 raise, that entire $100 is going to go to meet that $200 child support obligation. So obligors aren't keeping any of that. We're also seeing that people in that range are paying the highest percentage of their income toward child support. So that's kind of one pain point we're seeing. There's also an issue with those same folks when the obligee is on public assistance, because when when she has zero income counted on the guidelines, the other person has all the income, they're essentially getting 100% of the PICs, and that can cause a very high order. Whereas if that custodial parent had a job that paid similarly, even though that PICs would go up, so you'd be higher up in the chart, you'd see a better PIC split between them, which is to say they'd be closer to 50-50 in having that number, as opposed to if someone is on public assistance here in Minnesota, that's called MFIP, our TANF program, they're going to show zero income, leaving the other person with 100% of whatever shows up on that chart. So you can see someone that has a $400 order because the other parent is on MFIP, and if that other parent got a job, their order would drop $150, and their income stayed steady. So that's an example of 2 sort of pain points that we found with our guidelines that we need to see. There's also some complaints from the public about higher income obligors might have higher orders than are necessary. I'm not sure if that's kind of been verified or not, that is that we're much higher than surrounding states on there, but it's something that we get in public comments a lot. Other stuff I have noted here is that we recently eliminated our $25 application fee, and that's helped people access our services, and that this year we recently started online payments, and those increased our payments. Those aren't necessarily related to the guidelines, but just things that I wanted to note about things that maybe helped our performance. So that's what I've got on our guidelines. Do you have any more questions, or is there anything else that you wanted me to chat about today?
Yeah, ma'am, can I ask you, you talk about your performance. how do you look in that picture? What do the feds look at you as a high-performing state?
Yes, I think so. I was telling them the other day, I'm not really an expert on that, but I do think we're in the higher performing states. We only meet the things on 2 of 5, but I think that especially on our current, where we were like 5th in 2015.
And I think you said under the old model, you talked about maximum income, was it around 15,000? Are you still doing that under the new? Is there a max where you cut it off at looking at their income?
That's the new. That's right now.
That's right now.
The combined picks on our chart only goes to 15,000.
Oh, combined. Okay.
Yes. So if both parents made $7,500 a month, they would hit that cap.
I have a question, if I could. Madam Chair, Ozzie Fumo in Las Vegas.
Yes, I'm sorry.
Oh,
Go ahead,
no worries.
Assemblyman.
You had mentioned that you waived it was a $25 application fee?
Yep.
How significant was the increase in applications after you waived that fee?
I asked Kristen this yesterday. Let me see that. I think it was like 4%, 4 or 5%.
Thank you.
Just 2 questions. Karen Cliff from the Clark County District Attorney's Office. One, how agreeable are your parties? Do you find that you're having to make referrals often for judicial determinations? With respect to timeshare and some of these other?
Our system is administered by the counties. So it's hard for us to know here at the state kind of what the counties are looking at. I know that agreements are common, but often those agreements happen in the courtroom anyway. It's very, very, very common here that these go by hearing rather than by default. The counties do it. We have 87 counties, and counties do this 87 different ways as far as trying to default versus going ahead and setting a hearing. But frequently, parties do agree. However, even when they agree, that's often happening in a courtroom setting.
Understand. And are you noticing that your child support orders are higher post-2007 than they were pre-2007?
I don't think so. I mean, I didn't look at the numbers on exactly what that was, but especially in these recent years, there's been a big push to get sort of the right-sized orders, and I don't think that's just in Minnesota. I think everyone everywhere has been doing that. And that's not just a function of the way that we've set up the guidelines. You know, I don't think that comes just out of income shares. That's a push here to the counties to try and get the correct order for the correct family. So things like doing arrears management is helping to get more reasonable orders, getting those arrears off of there. We provide reports to our counties. There's 52 standard reports that we put out here at the state that they can use to analyze what's going on with their caseload in the counties. We do outreach on things, and I think that helps to get those right-size orders. We really try and get counties to engage their case participants to get that correct order, to get the order that's, I don't want to say low enough, but, you know, it can get paid, an order that is low enough that the obligor can pay it.
Thank you.
I have a question, if I may. This is Joe Sanford for the record.
Go ahead, Joe.
Thank you, Keith. You said that you're moving to a per-day parenting time compensation system, and that if there is nothing in the order with a per-day amount, that they are not getting that credit. If you weren't doing a per day before, does that mean that every custody order that's, you say, before you enacted these changes, is not going to have that compensation, and that they all need to go back to court?
Well, so we did have a provision in there that some of them are going to be sort of grandfathered in. So if you had come to court and you had gotten an order that said there's going to be reasonable and liberal parenting time, which is a common phrase here in Minnesota in those parenting time orders, and you said, well, it's reasonable and liberal, and we know it's going to be between 10 and 45%, because that's sort of what our statute, the range is, and the parties agree that it's going to be a 12% deduction, which is what that deduction is for anyone that is in that wide swath of parenting time. If you come in and you do have court-ordered parenting time, and you don't have that schedule, we're grandfathering in that 12%. So if we can't get to the actual number of days and you're back in for a child support modification only, and you're not asking a court to look at the parenting time, we're going to let you take that old deduction that you used to have when you modify your child support. But if new folks come in, say on a paternity, and they can't agree on what that number is, we're going to order it without it, and they're going to have to get kicked to district court to work out that parenting time.
Assemblyman Pickard, you go ahead with your question.
Thank you. I have two, if I may. First, I want to go back to the maximum. I understand that the child support guidelines stop at 15,000 combined max, but that the proration is based on the entire income. At least, is that understanding correct?
Yep. Yes, that's right.
Okay. And what happens when we have high-income earners involved? Did I understand correctly that it doesn't stop there? It just the calculation changes, and if that's correct, how does the calculation change?
No, they would. So you would go. Basically, our chart stops if you were to follow the 15,000 combined income over to 3 kids or something. So you've got 2 high earning income parents. Let's say your parents both earn $10,000 a month. So you've actually got $20,000 a month income. You would just look at the $15,000 column. You would go there, you'd pull that number, you'd split it by 50% because they actually have 10 and 10, and then that would be your number, the 50% proration pulled from the $15,000 column. Now, if you could ask for a deviation, that is in there, that if there's a lot more income, you can certainly ask for that to go up higher, but that is where our guidelines stop. We don't have a whole lot of cases involving high-income people on our caseload, so I don't think I could tell you kind of the pattern of what courts do or what people ask for, but it is built in that you could ask for more, but the guidelines numbers that would be spit out would be based on the 15,000.
Okay, thank you. And my next question then is dealing with the difference where you've got an obligee that is at home, doesn't work, the spouse earns a significant amount of money, and then you've got a relatively low income, maybe able to meet the self-support reserve, but doesn't have much custodial time. They end up paying a sizable portion of their income to someone who arguably doesn't need it. Is there a consideration in your system for that type of situation?
Well, they probably wouldn't have that high of an order. So there is a deviation factor for income disparities, but under the way it currently is, they wouldn't have that big of an order. You know, they might have like a $50 order. Because if they were coming in with $1,200 and the other parent made a whole bunch, they'd only have a 10% on the PIC split, plus they'd be hitting the self-support reserve or the minimum order. So typically those ones with that income disparity, if the parent, if the lower earning parent is the non-custodial parent, it doesn't always hit that high. It happens occasionally with kind of mid-level folks where there's a higher level and a mid-level earner, just because our parenting expense adjustment is only 12%. So where we see that biggest problem is where you get someone with more parenting time. So let's say a 40% parenting time, they're getting not that big of a parenting expense adjustment because we only give 12%, whether you have 10% parenting time or 40, and then they have enough income where that self-support reserve isn't helping them, and it's not totally throwing off that percentage PIC split. So there is kind of that one weird slot of cases with a middle earning parent and a high earning parent, and they both have close to equal parenting time, but not enough to get an equal parenting time calculation. But that's kind of getting in the weeds, I guess. I don't know if that was helpful. Sorry.
Well, no, I appreciate that, and it is. It actually raised a couple other questions. Number one, I wonder if you could talk to us a little bit about what your deviation factors are. And the other one was actually my scenario was where the obligee was not actually earning any money. They're say a stay-at-home mom. Their husband makes $20,000 a month. So technically, she would have zero income in the calculation. And you said initially that the income of the spouse is excluded from the calculation. So is there a deviation factor that allows for the court to consider what the household income is, even though the obligee themselves may not be earning an income?
And if I may, ma'am,
so you're saying that the low-earning parent has the children in their house. They're receiving the payment.
And ma'am, right before you respond, I just want to recognize Mr. Fleming. We know that you're on the line with us, and we'll get to you as soon as possible.
No problem. Thank you.
Thank you. Okay, go ahead, ma'am.
So did I understand? So we're talking about the lower earning parent is the one with the children.
No, it would be the, well, technically, yes. It's the non-income earning parent who has a wealthy spouse or a high-income earning spouse.
Oh.
Spouse's income, you said, was excluded from the calculation. I'm wondering, actually, maybe it might just be easier to cut directly to what are your deviation factors, because this may be incorporated in one of those.
Sure. So I did just pull up the deviation factors. I actually had it up in case I had this question because I knew I couldn't come up with them off the top of my head. But I will say in that scenario that you're talking about where you've got someone who's staying home on purpose and they have a higher earning spouse, we often deal with that via an imputation. So that person might be imputed a higher income themselves. Often when we see that, we see someone who used to have a good job and then decided to stay home with their new family or something. That person is going to have an ability to earn a lot more income, so we're going to impute income to that person. So that stay-at-home spouse is going to have income counted on our chart via that way without even getting to deviation factors. Would be a frequent fact pattern that we would see. And then as to the deviations, I'm just kind of going to ping through our statute here. They can consider all earnings, income, circumstances, and resources of the parent, extraordinary financial needs and resources of the child, standard of living the child would enjoy if the parents were currently living together, whether the child resides in a foreign country for more than a year that has a substantially higher or lower cost of living, which parent receives the income taxation dependency exemption and the financial benefit the parent receives from it, the parent's debt, and the obligor's total payments for court-ordered child support exceed the limitations set forth in another statute. There's a special section explaining when the debts owed to private creditors can be counted, and that's largely when that debt was accrued because of caring for the child, and then the income disparity between the parents.
Thank you.
I'm sorry, one last question. Karen Cliff, Clark County District Attorney's Office. How do you calculate the support where one parent has greater than 40% custody?
So it goes currently the way it is between 10 and 45%, they get a 12% deduction, and then between 45.1 and 55%, we do we take the regular picks in from the chart. We reduce that by 25%, so you multiply it by 0.75. You prorate that out between the parents, and then you offset them against each other. And I can just say that over again if you want.
And does it just go up incrementally as it goes greater than 55%, so on and so forth?
No. So right now we have two plateaus. So between 0 and 10%, you get no adjustment. From 10 to 45%, you get a 12% reduction, and then from 45 to 55%, you get that formula that I stated. So there's two sort of separate ways that you would get to it. And that is why we actually changed our parenting expense adjustment now, because essentially the people who had, that standard every other weekend schedule were getting the same adjustment as parents who had nearly 50-50 because they had, 43% parenting time. They were getting that same 12% adjustment.
Thank you.
All right, thank you, ma'am. We appreciate your time so much.
Thanks for having me, you guys.
All right, have a good evening. We'll move on to agenda number 5, report from Jim Fleming, North Dakota's Child Support Director, in regards to the child support calculation model in North Dakota. Mr. Fleming, are you on the line with us still?
Madam Chairman, I certainly am.
Thank you for joining us today. You have the floor.
Thank you. I'm glad to have that. And committee members, welcome. My name is Jim Fleming. I think you've received an email from me to your director with testimony that I had offered in 2015. That the material describes my background. I've been the director for 7 years. I was the deputy director and chief attorney for 8 before that. I've been involved. I've chaired our guidelines quadrennial review the last 4 times. In our state, by law, we need to convene an advisory committee prior to promulgating the guidelines. Importantly for us, that committee includes 2 legislators. It's historically been one from the Senate and one from the House. It's very beneficial for us because whatever the advisory committee recommends also then has some legislator support behind it. If ever the decisions of that committee are reviewed by legislative committees or bodies such as yourself. So we feel fortunate for the model that we've had. North Dakota uses what you've, I think, been briefed on called the obligor model, which means that we consider only the income of the parent who does not have primary residential responsibility. I'll call that custody simply because primary residential responsibility doesn't really flow off the tongue. It's a bit of a mouthful. The obligor model looks at one parent's income. It determines an amount of support then from that parent. My remarks that were disseminated to the committee include a provision from the guidelines that I think is very important. The last time that a bill was before the legislature to go to income shares, which was 2015, it was eye-opening to the committee to hear me describe the obligor model as coming up with a contribution. And the legislators wondered why I picked that word, and I said, well, because the amount determined under the obligor model is the contribution or an amount that the absent parent is required to pay. The custodial parent gets to pay all the rest of the bills. And then I followed that by explaining that the average order in North Dakota was $367. And the legislature said, is that all they pay? And I said, yes, that's all they pay. The rest is the custodial parent's responsibility. So even under an obligor model, there's no misunderstanding that the custodial parent gets free off the hook. The custodial parent pays all the bills minus whatever is owed and actually collected from the obligor parent. And so we have a provision in our guidelines that says that quite directly, that the calculations assume that one parent acts as primary caregiver. One of the challenges that we've had is if ever we were looking at an income shares model, how would you place a value on the amount of time of the care that a custodial parent is providing? That would be difficult to do in a shared income model. We do border on Minnesota. You'll forgive me if I sound a little bit competitive with Minnesota, but we're neighboring states, and that's just kind of how we roll. I've had the chance to talk to a lot of North Dakota attorneys, especially on the east side of the state, are duly licensed in both Minnesota and North Dakota. And I won't lie to you that a lot of those attorneys prefer the Minnesota model. My own brother is dually licensed, and he prefers the Minnesota model. So we have some pretty good discussions, and one of these times I'm actually going to go up and look over his shoulder as he does an actual Minnesota guidelines calculation. Our department has not opposed the legislation moving to an income shares model, but what we have tried to do is to convey to the legislative committees that it is an impression of fairness to go to that model, but in very few cases is it an actual, does it result in an actual change in the obligation. The difference between the clientele served by private attorneys, at least in our state, and the population that's served by the child support program is a matter of income and the level of precision. If you were designing guidelines that only applied to a certain economic strata at higher incomes, those are the folks that would tend to be able to pay all the bills. The discussion would be about the extras. Who's going to put money for a kid in college? Who's going to pay for insurance? Who's going to pay deductibles? For the higher income folks that the private bar is used to dealing with, that's time that is on average much better spent. But in our state, I would expect that somewhere between 80 and 90% of the guideline calculations are for low-income parents, where the economic reality is that these parents collectively cannot afford to support themselves and the child. So the best that we can do is to try to do some kind of an income transfer that helps support the child, knowing that there may still be some need for public benefits of some kind. So when you're looking at the predominant users of the guidelines being those at a low income, the time that is spent in looking at the income of both parents is really questionable. It's all work and very little gain or very little change. The previous speaker was talking about performance at a national level, and I got to give credit to Minnesota. They have passed North Dakota in the last few years in terms of the collection of current support. In our state, the oil boom, which led us to getting a lot of obligations increased because our parents were making historically high levels of income, the boom has turned into a bust. And now we have folks accruing obligations that are much higher than they can afford, and we have to go back into court to get those changed. So the current support measure in North Dakota has slipped a little bit in the last few years and is now below Minnesota. But when you look at the cost effectiveness of the program, on those same federal measurements, the cost effectiveness last year for Minnesota was $3.31 collected for every dollar spent. North Dakota is $6.15 collected for every dollar spent. And when you look at the investment of time and resources into guideline calculations, that change or that difference becomes a little bit clearer. If you want to dump the time into guideline calculations, we predicted that we would need a roughly 7% increase in our staff to make that change happen because of the labor involved in collecting income data from both parents. A 7% increase in staff. The costs that go with that would be significant, and yet at the end of the day, there'd be very few obligations that would actually be changed. The scenario that we could think of where an income shares model would result in a more equitable outcome would be when the income of the custodial parent is much higher than the obligor. Why would you squeeze an obligor for $200 or $250 or $300 a month when the custodial parent is making 10 times that kind of money or multiple times that much money? And so our legislature created a deviation criteria that was in my material, where they explained that the guidelines would have a deviation if the income of the obligee parent, the custodial parent, was at least 3 times higher than that of the obligor. In a case where you got a busboy for an obligor and a physician as the custodial parent, that guideline provision would allow for an adjustment. But by and large, parents in our experience, in our caseload, low-income moms have babies with low-income dads. Middle-income moms have babies with middle-income dads. There's a comparability there. And because of that, whether you looked at the income of both parents and did a proportionate split, or you looked at the income of only one parent, the obligations are largely going to be the same. For our state, I have to concede to my colleagues in the private bar, especially in the East, there are a lot more factors to consider. You can look at the obligation with a lot more precision, applying it to the facts of a given case. But even the folks from other parts of North Dakota who hear about the guideline calculations that these attorneys do on the other side of the river, they shake their head and say, man, I'm glad our guidelines are not that complicated, because they can have a calculation that's done relatively simply. The calculation is done on an online calculator that spits out the right number fairly readily. It comes up with a number that honestly, sometimes in my state, I think it's a little bit, or often just too low when it comes to the cost of raising kids. But it's what our customers are able to afford without being forced into the underground economy. So at the end of the day, what we've said to the legislature and looking at the model change is the model we have works pretty good. It is not broken. If you wanted to get fancier and you wanted to take more factors into consideration, that's certainly a possibility. There is some appeal to that, but the flip side is that we would need you to invest the money to add to our staff to be able to do all the more work. Even though, and then we say, and keep in mind, it's not going to change the outcome much at all. In fact, as I indicated in my prepared remarks, by and large, our obligors make more money than the custodial because they've maybe been the career person in the household, and the primary caregiver is the one that made profession choices that reflected their role as primary caregiver. They needed a job with a little more flexibility to take the child to appointments and what have you. As a result, obligors make more money. If you do a proportionate split of income, it actually might increase their obligation and not decrease it. We rebase our guidelines every 4 years. We look at the USDA data on the cost of raising children and the contribution of parents in single-parent families in the Midwest. That's data available by the Department of Agriculture, and that tells us that our guideline amounts at various income levels are consistent with what parents would pay. So we do that check every 4 years to make sure that the guideline amounts of support are in line with what they ought to be for parents, for single-parent families, and that is our check every 4 years for the guidelines. But it's not going to tell you that it's as fancy or as complicated as Minnesota, but I can tell you that for us, it has generally been led to a fair level of support where it's meaningful. Certainly as a percentage of income, it's meaningful, and yet it does not take the kind of time that other states would in reaching an obligation. No, so, Madam Chairman, I don't know if that is helpful as introductory background for our guidelines model, but I would certainly stand for questions or could go into any further areas that the committee is interested in.
I believe it was extremely helpful. Let's see if the committee has any questions for you now. Anybody in Vegas?
Assemblyman Pickard, if I may.
Yes, you may.
I'm wondering if, Mr. Fleming, if you could walk us through how the calculation is made.
I absolutely can. Let's take a straightforward calculation. We've got a North Dakota state employee payor. When we have a case that opens for that parent, assuming paternity is not an issue, perhaps let's say there was an acknowledgement of paternity in the hospital. So paternity is not an issue. So what we need to do is just establish the obligation. We would, at the opening of the case, we would send a communication to the absent parent indicating that we have an open case. We are needing to establish child support. Enclosed, please find a financial affidavit that we would ask you to fill out and return, listing your income and assets. Along with that, please attach your pay stub and your last tax return or two to be used in the calculation. We would take a look at those documents when they come back. We would look at the gross income of the parent. But then when we look at our guidelines, we would also apply the standard tax tables to reach a net income. We don't get into the business of second guessing how they actually file their taxes, if they file it as a household or if they claim a bunch of odd deductions. We would simply apply the standard deductions, standard tax tables, and get to a net income figure. That would be based on the gross income reflected in the W-2 with our own adjustment for FICA taxes, mandatory withholdings, union dues, that kind of thing. We would also then be inquiring on whether the obligor provides health insurance for the child. In North Dakota, we have a full funded medical plan at the state's expense. So in the case of this hypothetical state employee obligor, there would be no deduction. If the person was required to pay $100 a month to insure the child, then that would be a reduction from gross income to reach net income for guideline purposes. We also would subtract hypothetical state tax obligation. In North Dakota, we pay income tax as a percentage of the federal. So 14% of our federal liability is what we pay in state taxes. That would be taken or deducted as well. We would look at how many children it's supported for one child. That's the predominant order that we have. We would then go in the guidelines for that net amount of monthly income and for one child, and on the chart that would tell us what the presumptive amount of support would be. So to recap, we would be using the wage information of the employee. We would do some deductions to reach a net income for child support purposes. We would then look at how many children for whom the person owes a duty of support, and we would look on our guideline table, and that would tell us the amount.
If I can ask a follow-up. How can you walk through your deviation factors as well?
The deviation factors, forgive me while I pull them up on my computer here just to make sure that I capture the highlights of it. We do not, our deviations are fairly rarely applied. We have some things some adjustments that I need to mention that we technically don't call deviations, but they function much like that. If the hypothetical obligor in my scenario has remarried and has new children in the person's home, there is an adjustment for that support there is an adjustment for those new children. If the parent in the scenario also has extended periods of visitation, and that's defined in our guidelines, that will also lead to a reduction in the table amount of support. What we did many years ago is we used our statistics division to determine the amount of support or the amount of cost to the custodial parent that are saved as a result of extended visitation by the obligor. So our deviation credit is designed to hold the custodial parent cost neutral for the times that the parent that the child is visiting with the other parent. For example, you got a custodial parent that needs a two-bedroom home throughout the year, or a two-bedroom apartment. They're not going to change their lease to a one-bedroom for a period of summer visitation. So that rental cost is going to be fixed throughout the year. But utilities and groceries during the summer will be impacted by that. So with regard to the speaker's question, we do have an adjustment for visiting the other parent. We have an adjustment for other children that would be in the home of the obligor or to whom the obligor owes a duty of support. And then for our deviation criteria, which I mentioned are not applied very often, you have such things as as ongoing medical needs for the parent. The cost of daycare is a potential deviation. It's not one that occurs very often. There are others that are very fact specific, and we have found as we do our quadrennial review of the guidelines, we find that they're not even applied enough to be statistically relevant.
Thank you.
Judge Hoskin, if I can ask a question, I'm looking at what I think is your child support chart. I don't know what else to call it, but a chart. You called it something else. And it looks like for one child, essentially 14%, two children, 17%, three children, 20%. Is that accurate?
Yes, that's accurate when it applies to the low level or to the lower income level. If you looked at the
so the percentage
line,
changes.
You would see that that's 21%, 25.8%, 30.4%. At the 2,000 line, it is 22.5%, 28.1%, 33% for three children. So that amount expressed as a percentage does rise for a little bit as you climb in income, and then it tapers off and slowly starts to go down.
Okay,
and I could certainly provide that to you in a chart that's expressed as a percentage rather than these dollars amounts.
What I'm interested in is are you aware of how those calculations were determined?
Yes, they originated in the original guidelines through an economist named Espenshade. And that's getting back now, that's going back 30 years to when the guidelines were created. The Espenshade model used economic data that he had available at the time to know what people spent on children at various income levels. And we have adjusted that to reflect inflation and what have you, but that remains at the core of the division in this area. So that's why the percentage is expressed. It's at its lowest at the very low income, and then it increases to an amount today that maybe is around $2,500 a month, and then it tapers off after that.
And that hasn't changed for decades? Is that what you're telling me?
Well, the concept has not changed, but we have adjusted it for inflation. We rebased it in the last quadrennial review to reflect, to draw that line where it peaks as a percentage, to adjust that to the current minimum wage as opposed to what it was when Espenshade created his model.
Okay, thank you.
And as I mentioned, every 4 years, we take those numbers and we look at the current USDA amounts at various income levels to make sure we're still in the ballpark, and they have held true.
Is it just utilize the chart, or is there a cap? Does it ever stop?
It used to, the chart now has been expanded greatly, all the way up to monthly net income of $25,000 or more. I keep having a dream of visiting your colleagues in Vegas and walking away with one of those incomes. And it hasn't happened for me yet, but hope does spring eternal. But the chart does top out at $25,000 or more. It says this is the number you owe. It used to be a lot lower, and then we had some cases with those who had been very successful entrepreneurs in the oil patch, and they were making $200,000 a month net. And the court had applied a percentage to that income, and at some point this kid was being supported better than celebrity children were, and the Guidelines Committee was kind of pressured by the Supreme Court in a reported opinion that says, well, we're not fond of this outcome, but until the Guidelines Advisory Committee adjusted, this is an appropriate amount of child support. But it was a pretty big hint to us that we needed to cap the chart. So it is now capped at $25,000 or more in monthly net income, and it applies a percentage up to that.
Just one more question. Is there an adjustment for timeshare? For custodial timeshare?
You would find that adjustment in Section 8.1 of our guidelines. our legislature told us what the threshold should be. Our legislature decided that visitation needed to reach a certain level of magnitude in order for it to be appropriate for the custodial parent to receive less child support. So that's where the threshold was that was driven by our state legislature. They told us that extended parenting time means either a period of time exceeding 60 of 90 consecutive nights or an annual total of 164. And they drew that line based on research that showed the point at which the custodial parent experienced some savings due to the visitation.
And what is the adjustment once you get to 164?
The adjustment is the number of parenting time nights times 0.32 and then subtracting it. So it's essentially a 1/3 reduction in the support for each night that is exercised. So worded another way, if the extended visitation is occurring, our guidelines assume that 66% of the costs of the custodial parent are fixed, or 68 rather, and 32% are saved to the custodial parent and thus should be deducted from the obligor's obligation.
And does the adjustment take place all year round or just during the months, summer months kind of a thing?
All year round, it's averaged.
Mr. Fleming, Karen Cliff from the Clark County District Attorney's Office, just a follow-up question to that. How is that arrangement determined? Is it through your office or through the family courts prior to obtaining that reduction?
The nights are counted in the order itself.
Okay,
we
so
don't
there's a
ask
court
the
order
parents
prior
to
to
verify that the actual visitation has occurred as scheduled. It's driven by the number of nights that are explained in the order. Very few of the established obligations that we do in child support have that kind of a schedule in it. You would generally see that in an initial divorce or other privately arranged judgment, which later is then enforced by child support and perhaps modified by our program to reflect changes in income.
Okay, and that's similar to how it's done in our office. So you are requiring a court order prior to that reduction?
Correct.
Is that correct?
I would like us to explore the Texas approach where we have a presumptive visitation schedule that becomes adopted if nobody objects to it, but that's not where we're at yet.
Thank you, Mr. Fleming.
To go back to the gentleman's question, Madam Chair, if I could, who asked about the lower level or the bottom line of the guidelines, we are in the process of adjusting our low end on the guidelines to create a low-income reserve, which essentially just strikes out all the lines in the guidelines that are at the $700 income level or lower. For those low incomes, we feel like it's appropriate to provide a self-support reserve for the obligor and not to seek child support from that parent. So beginning January 1, if you drew a black line on our guidelines through the income line at 700, 600, 500, and so on, that would be what our guidelines are going to look like.
Sir, may I ask you, you started your conversation with us about difference in opinions between the private bar and your position. Do you have an ongoing dispute with the private bar about how child support calculations should be dealt with, or is it more abstract and theoretical?
Well, dispute would say it strongly. We have an ongoing dialogue with the private bar where they complain to me that they like the precision of the income shares model, and I remind them that in 80 to 90% of the times that the guidelines are applied, it's it's not time well spent, because no matter how you cut it, there's not going to be enough money to really support these kids by itself. You're going to have some kind of help. We have an ongoing dialogue on it. Ultimately, our legislature is the policy-making branch, and they've looked at the scenario and said the perception of fairness is not worth the investment of time and resources. And child support has encouraged them to consider that, because if they make the change, we need the extra staff. And if they don't make the change, then to the extent that we can, we review obligations more often. And that's something that really, it was something that really resonated with the legislature, is we make the feds happy if we review an obligation upon request every 3 years. We all know what kind of fluctuations and changes there can be in income every 3 years. You can be in a boom where they're making a lot better money, or you can be in a bust where they're not making anywhere close to that money. Fairness for our program is connected to right-sizing obligation. That's a term within child support. Right-sizing is adjusting the obligation up and down to reflect the periodic changes of income. Instead of doing that every 3 years, child support is going to do, in North Dakota, is going to do that every 18 months, which really, it provides a much more tangible level of fairness to the guideline calculation, because it tracks more closely the rises and fall in actual net income than the idea of looking at both parents and finding out you're going to get the same number at the end of the day anyway. So when I've explained to legislators the ways that we are doing reviews more often to improve the equity of the calculation, and how we would not have the time to do that anymore if we were needing to get income from both parents, that really, to the extent they needed a clincher, that was it. They said, well, we just don't see a reason for change, and we support the direction child support's going to right-size the obligations more often.
And when did you change to the 18 months?
That was a legislative change we obtained in 2015 to streamline the process, and I think we made that policy official maybe last month.
And have you seen, I mean, is it 1 month is not much time to know if it's increased
You're right.
Staff
1 month
needs
isn't
or...
enough to have the state. Yeah, 1 month isn't enough to back it up. I have been watching our current support collection rate the last few months, and it started to inch up. We previously had a list of exceptions to the 3-year review process if somebody was laid off, for example. But the list for exceptions got to be so darn long, we said, life would be a lot simpler if we just went to 18 months across the board and didn't fuss over these exceptions and whether they applied or not. So we have been trying to nibble away at that issue for quite a while. Our current support rate is inching up. Anecdotally, I know that our caseworkers that are working cases were wanting us to hurry up and get the form documents and the system support ready sooner rather than later so we could get going with that, because they know that their road for enforcing will be easier if they're able to have a more manageable obligation to begin with.
Do you know if there, at your legislature, if there was any pushback to the change to the 18 months?
There was not. There was the opposite. There was support from both sides of the aisle. On the conservative side of the aisle, they want to make sure that we're not too mean to these hardworking parents that owed support. And on the liberal side of the aisle, they were wanting to make sure that children would be that would be able to take advantage of increases in income for the payor. So it kind of made everybody happy to know that we were going in that direction. They agreed with us that it was just more fair all the way around. Knowing that fair is an extremely subjective concept, everybody just felt more comfortable with the more regular right-sizing of orders.
And how was your judiciary on it?
The judiciary was very supportive of it because I think they felt a little confined by the guidelines and were not fond of being faced with contempt hearings when there had been life changes in the interim that really created some legitimate reasons for non-payment. and they didn't like seeing, when somebody had been laid off, but they weren't getting a reduction in child support, the judges had a real hard time with that because they could just see this debt accumulating. And since it's a judgment, it never goes away, and they just thought the hole was getting deeper. And so they were going to have an easier time holding obligors accountable, knowing that if the obligor, that these obligations were adjusted more often. Then they would know that there's not that when they have a delinquency and they're asking about why that delinquency occurred, the judiciary was confident that it was much less likely to be because they'd been laid off and more because they were willfully not paying.
Okay, do we have any more questions from the committee? I don't see any additional questions. Mr. Fleming, thank you so much for your time.
Madam Chairman, I'm glad to help. Thank you.
We appreciate it. Hopefully you've helped us move forward and get some get some solutions here in the state of Nevada. Thank you for your time.
Very good. I'll sign off now. Thank you.
Mm-hmm. All right, we will move to agenda item number 7, a report from the Director of the Clark County District Attorney's Family Support Division, Mr. Watoon, in regards to, although he's with Nevada, he's going to be speaking to us about Wisconsin's child support calculation model and giving us his expertise on that.
Thank you, Madam Chair. For the record, Jeff Watoon. I am the Director of the Clark County District Attorney's Family Support Division. I've been with Clark County Family Support Division for the last 7.5 years. Prior to that, I have the unique experience of having been in the trenches as a Wisconsin lead attorney for Kenosha County, Wisconsin, for 10 years, from 1990 till 2010 when I came here. I've also been through some other guideline reviews in Wisconsin, a couple of them, as I was the Wisconsin Child Support Enforcement President for about 7 years. And I also currently sit on the NCA National Child Support Enforcement Association Board of Directors out of Washington, D.C., so I'm familiar with some national policy on this subject of child support and child support guidelines as well. I appreciate the opportunity of having been asked to come and speak here today about my experience in Wisconsin. I will give you one caveat. It has been about 8 years since I've been in court in Wisconsin, and so I'm more aware now of the Nevada law and try to remembering the specific examples, although they are listed in some of the materials that I provided you today. I may have to think for a minute or two. Essentially, in terms of a guidelines review in a state that's required by the federal government, the Office of Child Support Enforcement, every 4 years. In Wisconsin, having been on 2 of those over the course of 8 years, essentially the goals or the objectives or the overriding principles that we thought of in doing these guideline reviews is to make sure that there is stability and consistency in child support orders that are set statewide. In Wisconsin, there are 72 counties and 72 county courts, and I do bring the 4D perspective for the child support guidelines that I'm going to talk about. Obviously, that's my majority of my experience. And the reason for having consistency is to avoid deviation, which is what the federal government wants, except when it's necessary. And so that similarly situated families would achieve in ELCO what a similarly situated family would get in a child support order in Clark County. In Wisconsin, that's achieved with various charts and formulas that presumptively were correct and were to be utilized in all child support cases, whether they were part of the child support 4D program or non-4D program or the private, in essence, private cases. The guidelines also in Wisconsin, as here in Nevada, do provide for the ability to overcome the straight percentage model. That is Wisconsin's model, much like Nevada. Nevada, I believe, originally was modeled on Wisconsin. You guys ended up with, I got to change where I am. We here in Nevada ended up with 18% instead of 17, but we also agreed for 2 children it's 25, 29. It gets a little different at 31 and 34%. So Wisconsin is still a percentage model. Judge Hoskin?
Is it net or gross?
It's gross.
Thank you.
Yes. I think, and so I was talking about deviations, and basically you have the ability, there is still judicial discretion, whether it be with a hearing master or with a district court judge, that where to follow the guideline would be unfair, you're allowed to do a deviation, just like in Nevada, based on the fact that the judicial official who's doing so delineates, follows the deviation factors, which are pretty broad. And since you've had the other 2 guest speakers today go through them, I will tell you what Wisconsin's are. And as long as those factors are cited and the facts supporting the same are cited in the order, that's a valid basis for deviation in Wisconsin as it is in Nevada. With regard to and you'll see that it gives a great deal of judicial discretion, but in terms of the Wisconsin deviation factors, let me first talk about the materials you've been provided today. Wisconsin statutes for child support are called, the whole chapter is called Actions Affecting the Family. It's chapter 767. I haven't provided you any of those, although that's where these deviation factors are. If you wanted to look them up, they are at 767.511, parentheses 1 small m, in parentheses. And basically what those factors are to deviate are the financial resources of the child, the financial resources of both parents, maintenance, which is Wisconsin's word for alimony, received, or spousal support, received by either party, the needs of each party in order to support himself or herself at a level equal to or greater than that established under the federal poverty guidelines, or poverty levels, I should say, the needs of any person other than the child whom either party is legally obligated to support. If the parties were married, the standard of living the child would have enjoyed had the marriage not ended in annulment, divorce, or legal separation. The desirability that the custodian remain in the home as a full-time parent. The cost of child care if the custodian works outside the home, or the value of custodial services performed by the custodian if the custodian remains in the home. Oftentimes that comes into play with more middle to lower income folks where the custodial parent who has most of the time, and especially for infant or toddler children, it can be $1,000 a month or more, depending on how many children you have per child for child care, and having her to go out based on her education experience or any impediments to getting a job she might have, to get an $8 job at McDonald's doesn't really solve the problem of child care in that case and would be counterproductive. Additionally, the award of substantial periods of physical placement to both parents, extraordinary travel expenses incurred in exercising the rights to periods of physical placement by one of the paying parent, the physical, mental, and emotional health needs of the child, including any costs for health insurance as provided for in this chapter, the child's educational needs, the tax consequences to each party. Here's the favorite, the best interest of the child. That's pretty broad. The earning capacity of each parent based on each parent's education, training, and work experience, and the availability of work in or near the parent's community. So that you may be looking at imputation using that factor. Also, any other factors which the court in each case determines are relevant, which means these deviations could be limitless as long as you can come up with a justification. So that the ability to deviate also gets you beyond some of the questions that I think you had for some of the other speakers, and what do you do in those situations where the facts and the formulas result in an upside-down scenario that doesn't make any sense in terms of who's paying the order to who or how much that order is. The guideline, the other thing that you're considering in the goals and objections, other than the consistency in the orders, is one of the things is making sure that, well, Jim, my friend from North Dakota, called it right-sizing orders, but really it's based on the ability to pay of the non-custodial parent. And that increases the likelihood that the support will actually be paid and that it's not just an uncollectible number that sits on the books. And you should know that things have changed since the 1980s, when the child support program in this country was basically a government program recoupment for AFDC, now called TANF, as a collection tool to get money back to the government. Today, as it stands, 95% nationally of all child support that is put through our 4D child support system is paid into the homes of the custodial parent and families versus being retained by the states to reimburse for TANF expense. And finally, built within the formulas in Wisconsin, especially in cases where you have split placement or shared placement of the children between the parents, or a serial family situation, all of which I'm going to describe next, there is a cognizant attempt to work towards equalizing the child's standard of living or quality of life within both parents' homes. This is basically done by looking at both parents' incomes, using multipliers, and by assigning in Wisconsin the responsibility between the parties for variable expenses for the children. I know that in prior meetings there was discussion, well, who pays for ballet lessons? Who should pay for what? Why isn't that considered? Certainly, especially in the shared time formulas, that is to be considered. And if the parents with the variable expenses, which I'll describe in a minute, have a way they want to do that, the courts will defer to that. If they don't, there's the formula, and it tells them how to assign that, unless doing so would be unfair to one of the parties. So the Wisconsin Child Support Guidelines in a nutshell are something like this. And before I start, I did want to say something. There's a question of whether, are the Nevada Child Support Guidelines broken? From my personal experience, I don't think so. I think they just didn't go far enough so that so many cases you end up deviating, because life happens to everybody, whether you're a low income or a high income, and it's not intentional that one judge is nicer in Elko versus Clark County or anything like that. It's just the nature of the business. When you have the formulas, so long as the percentage guidelines, and this would apply to either state, so long as the percentage guidelines in this group takes a look at, is the 18%, given the current economic conditions of children and families and and job availability and what that is in Nevada through an economist, and if there's more recent availability of economic data than there was the last time we did this for real 20 or 30 years ago, whenever that was, if those percentages end up okay, as long as this state would then go ahead and account for those situations, for some of the formulas that my colleagues in Minnesota and North Dakota described, I think you end up with meeting what the federal government wants you to do in a guideline review, and you end up with fair and equitable orders. So, having said that, basically, Chapter DCF, Department of Children and Families, that's what that stands for in Wisconsin, 150, I did provide for every member of this committee and members of the public, I believe. What you need to know is that all of that is in such short notice. I basically was able to get a hand on what I call the Bible. From 2016, it would have changed somewhat or slightly in 2017. I've talked to some colleagues. There haven't been big changes to how Wisconsin does things in the last legislative session. They have them every year. There wasn't a guidelines review this year. The next one's next year. So the only thing that's updated to 2017 is the low-income poverty chart, because that one, at least in where I come from in the 4D world, where we're dealing with mostly low-income folks, that's the one we'd be using every day. Basically, Wisconsin is, like Nevada, is one of 6 or 7 states that remain on the percentage of income model. And again, I said that the differences were that we have these formulas. So let's start talking some of the specific formulas that you would see that I think would work both for private sector attorneys who are going to see people who, just by the nature of things, have more time with their children, may deserve the consideration of all these extra expenses, a reduction in child support based on that time, a consideration of the other party's income based on that time as well, which all will in the end benefit the child and hopefully the equalization, or as closest to it you can get, of quality of life within both homes. The serial family payor is DCF 150.04 sub 1, and this you do have. Basically, that's a situation where child support's being set for a child from a second family of the child support payor. So he or she has a prior obligation to support another child, whether that child lives with him or he or she has a prior child support order. Now, in Nevada, it's up to the judicial official whether to deviate from the formula and reduce this person's obligation to the second child, and by how much. Further, nothing would prohibit the judge or hearing master from going back on subject obviously to notice and having a hearing and the ability to be heard, going back and reducing the non-custodial parent's first child support order because now he's got a second child. Under Wisconsin law, there is a permissive formula for the child to use, and along with a strict prohibition on reducing the non-custodial parent's first child support obligation based on the fact that he's now picked up a second obligation with a new family. The theory based on that is you had this child support obligation or legal obligation to support this other child when you decided to go have this other child, and you're responsible for that decision. And so you should not be rewarded for that behavior. Now, the serial family payor formula does reduce that obligation for those subsequently born children to the second family, third family. We've seen it all, and it does do that. It should give for you an example of how that's done, and the formula, unless you need me to, I didn't want to run through every part of the formula. It's well laid out, and the examples I think are pretty good. The second one is shared placement
Mr.
parents
Witun, can I ask
situation.
you real quick? What was
Absolutely.
What was? Don't go through it, but what was the statute number for the serial parent payor formula in Wisconsin?
I'm sorry, it's in DCF. These are the administrative codes.
Okay.
So the first thing, Chapter 767 is Wisconsin statutes. The codes are where the child support guidelines referenced in the statutes are. That's Department of Children and Families, DCF, Chapter 150. That's the documents you should have with you today, where you find all of the guidelines. Sorry if I didn't make that clear. The second one is the shared placement parents situation, much like the Wright v. Osborne, the way that we've tried to handle it here without statutory guidance. That's section 150.04 sub 2. And that's basically where the situation where both parties have enough placement time of the children during the year in their household to justify a different calculation for child support. And what I was hearing, and I wasn't familiar totally with Jim's guidelines in North Dakota, but in Wisconsin, that starts to occur in terms of reduction in child support at 25%. Of the time. And those can either be overnights, and later on they change that to overnights or the equivalent of overnights, because there are situations where, if kids are showing up at 9 o'clock at night, spending the night in the morning just having breakfast versus being there all day eating lunch and maybe dinner, the expense could be the same or greater. So overnight or equivalent is the standard. Once you hit, it's 92 overnights per year, essentially. There, the formula considers the income of both parents. It also inserts a 150% multiplier. So when you're running the calculations, it's essentially a 1.5 multiplier to account for household maintenance expenditures that are duplicated by both parents, like bedroom, clothes, personal items. So there's that equalization between household factor that you're thinking of. Also, in this situation, the courts must assign the responsibility for the child's variable costs above the basic support costs incurred on behalf of a child, such as childcare, tuition, special needs, and other substantial cost activities. So that could be football, dance lessons, Boy or Girl Scouts, those kinds of things. The formula to assign, if the parents don't otherwise agree, suggests that the variable cost would be assigned in proportion to the time that each parent has the child, but with due consideration given to the disparity of the parents' incomes. So if you did have two parents who, one had 60, one had 40% placement, and their incomes were substantially similar, you would have the parent with 60% of the placement doing 60% of the variable costs, the person with 40% of the placement doing 40% of the variable costs. Just so you know, with regard to the variable cost allocation, that is not something that the child support system in Nevada can put in and charge and deduct. That would be an obligation between the parties. But it is still a valid court order. Obviously, if at the end of all these calculations within this formula, and there is an example, if it became, if it was going to be higher than under the percentage guideline, you'd still be paying the percentage guideline. And if the low-income guidelines would apply, well, that would trump everything. Because again, it's based on ability to pay, not numbers that you can't ever get paid. Essentially, the policy is that an ability to pay, because and you hear it all the time, and it's true. So if you do a low-income guideline and someone pays, for example, in Nevada, $100 a month for a child, well, $100 a month, and if the custodial parent has that child, all but a weekend a month or two, that doesn't feed your child for 4 or 5 days. But I think what the argument is that that's why there is also the public safety net, and so that if you're in a low-income family on both sides, the custodial parent will have the advantage of having the public safety net, and then whatever the non-custodial parent who is also low-income can afford and has an ability to pay to right-size that order. We'll talk a little more about that when we get to the low-income guideline. The split placement parent situation is DCF 150.04 sub 3. That's where each parent has primary placement of one or more children in common. So, example, mom takes the son, dad takes the daughter in terms of primary placement, and basically you use the percentage standard for the total number of children, that's 2, so you do 12.5% of each of their gross incomes, and then subtract, and the person with the greater amount left pays the child support to the other. The next item is the low-income payer child support obligation, DCF 150.04 sub 4. It's a chart listed towards the back as Appendix C, which is based upon a child support obligor or payer whose income is so limited that it would be unfair to use the percentage of income standard against him or her. That chart is revised every year. That's why I did grab the new one for today's proceedings. And it's based upon the federal poverty level, which is also changed every year. And announced this year's for 17, and the way the child support guidelines are applied in Wisconsin, they look at in Wisconsin between 75% to 150% of the federal poverty level. If you fall there, you qualify for those guidelines. It would fix the concept of Nevada's, and this is especially prevalent in child support court in terms of the 4D program, is one of the things that Jane Venor in her report indicated that while $100 a month for one child might be okay for low-income guidelines, once you get to 2, 3, 4, however many children, it becomes impossible for the gentleman or woman to pay the non-custodial parent. So if you look at Wisconsin's, you're looking at for one. I have it in front of me. I'm supposed to, but basically for 3 children, you're at $100 and something per month. It's on the chart, as opposed to $300 per month, and it goes. So it still ties into the ability to pay, collecting of the child support, rather than being an obligation which simply cannot be fulfilled by many of the low-income obligors due to impediments such as lower education, possible criminality, lack of job prospects, that's lack of stability. And so it gives them a greater chance to be able to pay something towards their obligation as opposed to nothing and choosing to feel hopeless or feeling hopeless, not choosing to, and then simply trying to do your best to avoid the child support program and the obligation altogether because of the sense of hopelessness. Another interesting thing is a little different than Nevada, and I think Ms. Venor talks about it in her report as well, some of the issues with Nevada, is the high income payer child support obligation, which is DCF 150.04. They talk about, or she talks about Nevada in terms of a firm cap, which in some situations can be so low as to be detrimental to the children and would drastically alter their quality of life in one home that they should probably be entitled to. In Wisconsin, there's no cap. Essentially, here's how the court does it. They use the percentage of income standard up front for the first $7,000 a month, which is $84,000 per year. Then for the income between $84,001 to $150,000 a year, it uses a different percentage standard, which amounts to about 80% of the regular standard. Then for all remaining income from $150,001 upwards to infinity, Wisconsin further reduces the percentage standard applied to that set of income, which amounts to about 60% of the regular percentage standard. Now, at some point, I agree, that can get ridiculous, but then again, you have those deviations where it might be unfair to one party or another, and you can go and use a judiciary could, hearing master or judge could say, hey, we're going to deviate a little bit here because, no kid, even in the best interest of a child, needs, $100,000 a month or whatever that looks like for Spielberg's kids or Barry Bonds' kids or whoever else might have a child support order. So there's that. Also, and for fun, and for a brain teaser, I'd ask that you all go home and try one of these. There is a sample here, is where you have the combination split placement, shared placement. So mom and dad, have one child primarily with them or two children and one child, but they also have periods of more than 25% of the time with some other children. And there's a fun formula, brain teaser, if you want to do that. But I just appreciate the fact they thought of that. So they tried to think of everything. The last thing before I get to a couple of other interesting pieces in Wisconsin law, and then I will wrap up, is the medical support. That's at DCF 150.05. As in Nevada, an order covering health insurance or medical support orders for the children is required in family cases. In Wisconsin, it talks in great particularity. What do you do in those situations and how do you assign it? And what if someone's too broke to afford private insurance, which that's an amorphous concept these days as well, because they call it, if you see a reference to Badger Care in here, that's basically state Medicaid. They just made it a neat little name after Bucky Badger. But when you can assign that responsibility, oftentimes we would say if it's available at reasonable employment at reasonable cost, which is also defined in there, we'd say that both parties many times should provide it. In many times that means you're not going to end up with any insurance. Now with the Affordable Care Act a few years ago, et cetera, more than likely what you may have is some either Medicaid or something else that requires a lower copay of usually the custodial parent. And so you can assign costs. You can adjust the child support order to say, hey, you must pay, we're going to adjust it up a little bit for you to cover some of that copay, do that as a separate order. But I let you read through that because it gets into if you're over the poverty or under poverty level, you aren't going to be able to do anything unless it becomes available in the future. So they really do look at the low income stuff, and that's it's kind of a pretty neat thing that they do. That's essentially the child support guidelines, other than a couple other things I wanted to point out that were of interest or hopefully are of interest to this committee. In every child support action for paternity or if parties are married but separated and no one's filed an action for separation, annulment, or divorce, and child support gets involved either through a application of the custodial parent or an automated referral based on that custodial parent because the husband with the job is sent, as an example, has left and she's picked up public assistance for herself and the children, must make at least a temporary order for legal custody and physical placement. Now, in the 4D world, the child support attorney is not supposed to be commenting in the court on the custody and physical placement because that federal dollars don't go for that at this point. However, we were left with that statute, and what would normally happen is that we had our hearing masters were called court commissioners. So our court commissioners would, and this is maybe 80 to 90% of our cases, because again, in the 4D child support world, often 60 at that time, 60% of my cases had some form of public assistance awarded to one parent because they had placement, primary placement of those children just by facts of life, or paternity hadn't been established, so dad had no legal rights at that time. Or they'd filled out a voluntary paternity acknowledgement, but hadn't worked anything out for the most part with themselves. And so they'd walk into court if they both bothered to show up, and the court would indicate, ma'am, you're on public assistance with these children. Yes. Do they primary, and I'm just using an example, it could be sir, but most of the time it was females. Do they primarily live with you? Yes. Does he see him? Well, he sees him every other weekend, or he comes over once in a while, or this or that. Okay, so it's very, let's do so the placement would be normally ordered at 90% of the time, primary physical placement to the custodial parent, periods of secondary physical placement to the non-custodial parent upon reasonable advance times and reasonable advance notice to the custodial parent. This is an order that can be taken up with the district court judge, and if you'd like to do that, where they get parenting plans and guardian ad litems, they were free to do that, and that was in the order. As for legal custody, that's the right to make essentially 6 legal decisions in Wisconsin on behalf of the children, getting a driver's license, getting married before the age of 18, joining the military, schools, doctors. One more that escapes me, but I used to be able to recite it off the top of my head. Essentially, if the custodial parent was there and said, you want to share those decisions with the opposite parent? Yes. The answer is joint legal custody. No, or he's not there, or he's never around, or primary legal custody to the custodial parent. And those would be fairly quick orders. Now, if parties did come in, I think much like and they had some kind of arrangement, we could put that on the record and seek for them to finalize that through mediation or district court or what have you, and adjust for the child support order. So it's interesting because one of the things I find unfair about Nevada, and right now there's nothing I can do about that, is that while you create the legal obligation under a separate case in our case number in our child support court, the 4D court, and then suddenly the non-custodial parent is ordered to pay hundreds or thousands, whatever it is, in our case usually hundreds of dollars per month, to support his or her child, but they say, I can't see the child. And what we do here in Nevada is we say, well, that means you need to go spend some money and go over to the district court and file your own motion. And if you know anything about some of our lower income non-custodial parents in our caseload, and we have 54,000 cases just in Clark County, for them to get over that hurdle is significant for many of them. And so I find it a little unfair that while you're ordered to pay for your children, you may not, if the parties are working it out, that's one thing. But if they're not, you're really stuck with for some folks, an unimaginable hurdle. And so that is one piece I never liked about how we do things here. Also, studies show nationally that when both parents...
I'm going to interrupt you, Ozzie Fuma, for the record. What did they do in Wisconsin in a situation like that?
In a situation...
where you had the non-custodial parent paying $100 a month but wasn't not able to see their child.
So if we're in the first hearing, the court has to set at least a form of temporary order for custody and physical placement. So if both parties are there and he says, she's not letting me see the child, depending on the age of that child, or if they've never had a relationship, and that happens once in a while too, they can order because there are programs available in the community I was in to have supervised visitation or meet at a certain spot, or hey, for this, often it was infants, and it may be 6 months before we got into court. Kid 6 months old has never met dad. Hey, mom's going to be there with you as you integrate this, but this is a temporary order. You should go to superior or district court, and they have the ability to order those things so that something can be done. Now, if mother's saying, this man beat me for the last several years, and well, then that's something that would probably, in the commissioner not knowing any other facts, would say, right now we're going to order temporary everything and we're going to get it put on for district court, order a guardian ad litem is what they'll do there to represent the best interest of the child and get into what that should be. But something will be done. He or she won't be the non-custodial parent left hanging at that initial hearing. Something needs to be done. And where alarm bells are going off, that's how the court commissioner would structure the order accordingly and set something up for the future. Did that answer your question?
Yes, thank you.
Oh, thank you. And I'm almost done. The other thing is kind of is different from Nevada. The courts are required in child support actions to assign the responsibility of which parent shall claim the dependency tax exemption for the children in the case, which I am no tax expert, but I often do try to go to tax law, CLEs, and things like that, and there can be disparate results. And now with the Affordable Care Act, there's penalties and it's. I'm not saying that necessarily the courts here should do that because often it's confusing for not only the hearing masters and judges but the child support lawyers themselves. But it is a question that. Folks, at some point, if you pay enough child support, if your orders are high enough, my guess is the private bar would be interested in this because they actually have to work it out in all their divorce cases, because in a formal life, I did divorce cases for 2 years. Anyway, it's required to be assigned, and it was very difficult to do in child support court, except in this traditional case where whatever dad's paying in child support isn't going to be greater than 50% of the care of that child anyway, so mom gets to keep it, essentially. Liability for past support. This is an interesting one, and this is one that I actually support. In Wisconsin, this is limited to the period not only after the birth of the child, but also to the time after the child support action, whatever that is filed. Divorce, separation, an action for child support, a voluntary paternity acknowledgement seeking child support on top of that, a paternity action. So it's limited. It encourages people to get into court earlier and have these things taken care of for their children. However, there are exceptions. Those exceptions include where that filing was delayed by the non-custodial parent because of threats, duress, false actions or promises that the custodial parent relied on, or evading service of process. So here I think we can go back about 4 years. I find in many of my cases that simply creates an insurmountable amount of child support arrears set that makes the non-custodial parent not want to cooperate and run far and run fast. So that's one of the things that Wisconsin did back in 2000. When I first got in the program, that was one of the new laws they enacted, and I think that's an interesting thought. And it also prevented the situation where I represented privately a postman once in my first paternity case before in private practice. And there was an 11-year-old child he knew nothing about, and it was true, he really knew nothing about it. And all of a sudden, mom went on public assistance with that child after 11 years, and we set 11 years of postman's wages in child support arrears on that poor man. So I always think about that case, and I think it's inequitable. Finally, Here we have interest and penalties, and Ms. Venor does refer to that in the court. In Wisconsin, interest, while I was working there, was always based on 1% per month or 12% per year, which was essentially tied to the interest on judgments rate under Wisconsin statutes. One of the things we always wanted to do was to find a way to reduce the interest rate from that rate. And you have arguments on both sides. You know, the time value of money, the custodial parent was out that money. There deserves to be some form of compensation to her for having to wait, or him, to wait for that money. But my understanding of how Nevada ended up with interest and penalties, and someone can tell me if I'm wrong, but the rumor I heard is when we went to get them several years ago, we asked for interest and penalties, hoping we'd get one, and we got both. If that's not true, I apologize. That's just the rumor I heard. However, I think what would be important, the interest here wouldn't be so bad if it's based on the CPI plus 2%, so it makes it around 6%. Wisconsin, in the last couple of years, one thing they did, they called something, they got through the legislature, something they called a pilot, because it's less scary than simply just permanently changing a law, and they made it 6% and to track it, and it has no end date. So essentially the interest is now half of what it was, and if Nevada just had the interest the way it calculates now and no penalty, one, there wouldn't be an argument between the private bar and some of them and my office about how you calculate interest and penalties and who's right and who's wrong, and there'd be a lot less need to write articles on that. But it also would be a lot more equitable because the interest, you know, 90% of the arrears owed in this country on child support is owed by the 10 or 11% poorest people in the land of the obligors. And so adding interest onto that is just another number you won't get. And then at the end of the day, when the paper says, how much is in arrears in Nevada that aren't collected? Well, that number is $750-something million. Well, that's an awful number. But it's based on years and years of setting orders too high and interest and penalties and things like that. And so with that, I will entertain any questions at all if you have them. I apologize for speaking so long. I hope that I did cover some of the things that Ms. Venor did in her report and hopefully gave you guys some things to think about.
Mr. Wittun, thank you so much. I appreciate your time. I want to ask you about another provision that's in the Wisconsin code under DCF 150.03, subsection 5. They've got an adjustment for the child's Social Security that the child receives. And I just wanted your opinion on that.
Oh, I can talk about that. What was the number again?
It is 150.03, subsection 5. It's the third page.
Yes. So the way that we did that, and I don't think the chart's in here anymore. It used to be in here. Essentially what that does is if the child is receiving a monetary monthly benefit based on the disability of the non-custodial parent, you can adjust the child support obligation by subtracting the amount of that Social Security benefit from what would be required under the percentage obligation. There used to be a little chart. It was a simple little chart that you could do that, but we oftentimes made that obligation. I think it's in Nevada we essentially do something similar, generally out of fairness, but there and oftentimes the order would come to zero because the amount of benefit that the custodial parent was receiving for the child into her home based on the non-custodial parent's disability was going to be greater than what his child support order at 17% of his $1,500 or $1,000 or $1,200 would have been. And it's actually one of the things that we do here in Clark County. We're the first program in the country to have hired a social worker, and we now have two, that help our non-custodial parents who suffer physical and mental disabilities try to get through the Social Security process without a denial the first time, which are often, in my opinion, automatic. So SSA won't ever admit that, but the reality is, and then you're on to the 2-year appeals process. That they'll admit to. It's just important that we are able to have our social workers guide them through this process, because so that we're able to we have them sign medical release forms so that we know, because we know how to get their medical forms from their doctors, what their doctor should sign, and be indicating whether they're permanently disabled or whatever that is, if there's no ability to earn income, and have had much more success that way. And in our office, we do the right thing, and oftentimes those orders do end up at zero, and the courts find no ability to pay. In Wisconsin, they do the little formula here, but essentially it comes out to be, in my experience, having done hundreds of these while I was lawyering for 10 years in child support court, at either zero or probably under $100 a month, because of the amount of, whether it's disability or retired, the amount of income to the disabled or retired person based on Social Security, that's all they've got, is so low, your child support order wasn't going to be much anyway, and the kid's getting a greater benefit. Did that answer your question, Madam Chair?
Yeah, I think, and once you started talking, it dawned on me the language in here based on a parent's entitlement to the benefit.
Right, it's the non-custodial
versus the child.
Parent.
Right. Okay.
Right. So it's his disability that if he wasn't disabled, it's that money. So he's contributing, and many times we find, at least in our program, especially, that it's a win-win for the whole family. It's essentially in lieu of a child support order in lieu of a child support order in a greater amount than the custodial parent would have received if we just set the child support order just off the Social Security.
Judge Robb, for the record, thank you also for your remarks. I have a question, and I've been looking at the regulations here as you've been speaking. What I can't find, and I'm hoping you can help me with, is how does Wisconsin deal with a household where you've got two wage earners? So the obligated parent is now remarried. That spouse is also bringing home a wage. In Nevada, obviously, we're looking at relative income of households, so we would consider that as part of a deviation. What happens in Wisconsin?
I think that's very similar, that you could look at what you can't do is directly use the other spouse's income to say, hey, you need to support this child that you haven't adopted, just because you're a step parent and married the mother, for example. However, I've had lots of cases in my former life where you'll have someone claiming, look, I can only afford the money available to me, because this is where it's relevant. The availability of the money to the non-custodial parent to pay child support. And he's going to argue, but I've got, all these other, I've got to pay the mortgage, I've got to pay for this, I've got to pay for food, I've got to pay for that, so there should be consideration for that. Well, if in fact you can show that the wife or girlfriend is paying for all of those expenses, that frees up other money for child support, and so you may be looking at deviations as well.
Thank you.
My pleasure. So, Karen, how much over a half hour did I go? Oh, okay. I don't pay her to say those things. All right.
I think you did great on time. We absolutely appreciate your time. Does anybody else have questions while we have him and can abuse him at the moment? No, thank you. We appreciate it so much, and having your additional insight into knowing Nevada helps tremendously.
Thank you. And just in closing, I'd like to say I can appreciate the enormity of the job that you folks have after 20 years. And bless you all. And so if there's anything I said here today that helps, I'm just thankful, because I care very much about where I am now, because this is home. Thank you.
Thank you. All right. We will move on to the next agenda item. What time are we at? 2:45. All right, our next agenda items, number 8, to begin our discussion of the recommendations detailed out in Exhibit 44. We have agenda item number 8 broken into 3 parts, 8A, 8B, and 8C. So we will start with 8A, which is the discussion of the premise and basis of the Nevada Child Support Guidelines model and recommendation as to whether the base guidelines percentage formula should be changed pursuant to items number 2 and 3 of Exhibit 44. So items number 2 and 3 specifically state, review the premise and basis of Nevada Child Support Guidelines model. And number 3 states, determine whether the base guidelines percentages formula should be changed. And based on, of course, we didn't go through every single state and their guidelines calculations, but we appreciate the time that the state put into getting us the reports that we did get on those 3 states to guide us in this discussion about these recommendations. And do we have anybody that wants to start the discussion?
If I can ask a question?
Sure.
Is Nova up there? Did she arrive?
She's not here today, no.
All right. My question is one that actually came up as we were looking at Mr. Fleming's discussion as to what the impact to the state's going to be if we were to substantially change our approach. And so I'm wondering how that might play in. I think that's going to affect how we move forward on this.
Nova is not present, and I don't know whether or not this will be a question for Ryan. We do have other employees available from the state that may be able to respond to that question. Primarily, I'm hoping David maybe might be able to, or Janelle might be able to give us some insight if...
Yeah, you can go ahead and ask David if he's willing to answer.
I just
David or
recall
Janelle?
Nova saying something about they're in the process of updating their computer systems, and so now is the time. I was hoping that she would have some idea of what a change would require in terms of cost as part of that.
David Castagnola, for the record. I am a social services program specialist with the Division of Welfare's Child Support Enforcement Program. And no, we're unprepared to provide that, although we certainly can get that information. Ms. Murray may have that off the top of her head, but we don't have that with us today. We would have to do a cost analysis. It would be a substantial impact. But to put a dollar amount to that, or an estimate to the number of cases that could impact, we would have to get back to you with that information.
If I may, real quick.
Well, Madam Chair, I think that would be interesting to know, because what I want to avoid is an effort where we go through 3-4 months of coming up with guidelines if we were to go to the shared income model that then would be completely out of reach of the department to fund. It would put us in a real bind. I think that before we make any final determination as to which model we're going to move forward, that we know what those estimates are and whether or not it's realistic to think we can. And maybe even broaden that question a little bit and say whether or not we care.
David, while we have you here, to differentiate with Nova's comment last time on the record, I believe it was regarding the fact that during this legislative session, you did receive money to completely overhaul your software system, but what we don't know about is the additional staff costs or how it would change how the department works in calculating or the work behind collecting child support and doing the actual cases. Is that a fair statement?
David Castagnola, for the record. Yes, I believe that's a fair statement. The sum of money that you just referenced has to do, as you said, to get a new computer system, which is an 8-year project, a 7 or 8 year project, multi-million-dollar project. It's a different pool of money and totally separate from the impact on casework. That would impact the child support program, which is staff and county in 9 out of the 17 counties. Essentially, caseworkers would need to secure custodian income on every case that we establish within the year or modify. And we have somewhere around 100,000 open cases. Some of those are in enforcement, some of those an obligation needs to be established. But I don't, off the top of my head, know the number of cases that we establish every year or modify every year. And again, workers would have to obtain custodian information on all of those.
So I think Nova's statement that if we were going to make the changes, the time is now, is because once that software system is developed, to rehaul it again is the impractical part, at least on the software end of it, not on the other end of all the other additional costs.
Correct. I think what she was referring to is we're at actually October 2nd is the next week's the official kickoff of the project. We're at the design and requirement identification stage of the process. So if we were to have a new guideline model and the new system can be built to have a calculator, like for example, Mr. Fleming in North Dakota mentioned that they have an online calculator. Well, that could be built into the system. So now, before the system's designed, would be a good time to know what sort of calculator to build based on the model that the state follows.
So our 2018 deadline that we have isn't really practical with that anyways, if you're already starting the design phase in October of 2017.
I honestly don't know the timetable of the project. I don't know what is dedicated to requirement identification and design. Out of a multi-year project, that 2018 deadline may be timely.
Maybe timely. Okay. All right. Thank you. Appreciate your time. Assemblyman Pickard, my comments on that, just my input on it, since we're on this discussion of the basis of our guidelines, I'm inclined to say that I'm in agreement with Mr. Watoon, and I'm also probably, whether Judge Hoskin is still on the same page or not, I don't know that we're completely broken. I don't know that I think it all needs to be overhauled. I love the way that Mr. Watoon phrased it, which was we just didn't go far enough. We don't have what we need for all these different scenarios and these different family dynamics and the situations that we need. That by fine-tuning what we have, we may get to the same conclusion. It also kind of, although I think Mr. Fleming's model, or it's not really his model, his state's model, may be too simplistic, in my opinion, in addressing the needs for income share. But I think in looking at Wisconsin, they seem to really take that into consideration, even though they're not an income share model, because they've got all these different scenarios for different kind of family dynamics that we're missing. In preparing for today, just for my opinion on Exhibit 44, Sections 2 and 3, I came in kind of prepared to say exactly that I think we can get to those changes and those fixes that'll make a dramatic change in Nevada without completely overhauling to an income share model. And I think part of that comes from my really trying to understand and respect what will happen to our state and what you're talking about with costs of what will happen to the district attorney's offices when they have to start collecting that income information on both sides and the practicality of that. But that's what we're here for today, is to debate that topic right now to see kind of where we're going.
Thank you, Madam Chair, and I agree with you. One of the things I had not considered was the human element. How much are we going to have to change the practice of law in Nevada? Not only do we have the district attorney's office, but we have all the private practitioners. Everyone would have to make a pretty substantial change in how we do business. And so I found it somewhat refreshing when Mr. Withtoon asked the question, is it broken? But I agree, that's up for discussion. I'd love to hear more, but I'm leaning in your direction.
This is Judge Robb for the record. Madam Chair, I agree with you, and part of what informed my decision was I really tried to be open-minded here today, to listen to what people had to say so that I didn't come in with some kind of preconceived bias. I found very, very important the information that we got from Mr. Fleming indicating that North Dakota, which doesn't use the shared income approach, has a 2 times better cost effectiveness rate than does its neighbor Minnesota, and they do so with very little. Let me back up and say they do so, and with the additional costs that Minnesota spends, they're not getting a whole lot more in the form of collections for their state. If you don't get the bang for your buck, I don't think it's appropriate for us to make a recommendation in Nevada to spend more money than what is appropriate to be able to really get the collections that we need to get, especially on the 4D side.
I'd throw out there before anybody else comments, just for the record too, obviously Judge Robb wasn't here during roll call, and Mr. Sanford was not here during roll call, but are present in the meeting. We have other thoughts on number 2 and 3?
Sure, I'm happy to weigh in, Judge Hoskin. I don't know that my position has changed from what I was trying to put across at the last meeting. I do have to say that I thought Minnesota was dizzying trying to keep track of what they do and what they don't do, and the additional cost, not just monetary cost, but in retraining and trying to retool exactly what's going on. I wrote down Mr. Fleming's comment, perception of fairness is not worth the time and resources invested. If we can show statistically that it's still fair and keep it to the type of model we have now, my suggestion, and I think I'm still in line with you, Madam Chair, is that we take a look at where we are and we'll make some tweaks if we need to make them, and we'll get to 5 and 6, I'm sure, as well. But I think that's part and parcel of the big picture that we're trying to accomplish here, and I believe that we still accomplish fairness by making that happen without a huge expenditure in many areas that I don't know is necessary.
And Madam Chair, if I can just interject, I know Ms. Throne wants to jump in as well. One of the comments that, or one of the findings that Ms. Venor made in her report was that even though we have that stair-stepped, somewhat arbitrary calculation, it does put us between the two extremes, somewhat in the middle. Better in one end and not so at the other, but we're still within the realm of reasonable, and so I agree with Judge Hoskin that does make some sense. If we are, more or less fair, then we need to, I think we need to consider minimizing the amount of human capital that needs to be spent on retraining and the like.
I don't want to downplay that, except for her conclusions were that with data from the 4D cases, without data from the private cases. So I still have
a good point.
Yeah, so I still have a concern about how we work on, with those cases. But I think between the members on this commission who have plenty of experience in private cases, the specific things that Mr. Withtoon laid out, specific things that this report lays out that we need to change, will make a big difference in private cases, with or without the data. I don't know where that curve would go on how we land on fairness when you add in the private cases, but I do have a belief that perhaps these kinds of changes will make a difference for those cases. Ms. Throne?
With regard to, I come at this from a private practice, so most of the cases I'm seeing, and Judge Hoskin probably can correct me, most of our cases, we're dealing with shared custody. 80% of the cases now are probably shared custody of some sort. So we're always gathering data on the income of both parents. Are the 4D cases so different where they are an overwhelming percentage primary custody to one parent, and it would be that much of a burden or not? If they're going in 4D cases also to a shared custody in a lot more cases, I mean, our society is changing. Our custody approach in Nevada has changed a lot since I've been practicing.
I think that's me. This is Karen Cliff from Clark County DA's office, and I want to say that I agree with you, Madam Chair. I would like us to maintain our current model, but beef it up substantially, and I like many of the provisions that Wisconsin has. A change would impact us on so many levels, not all of which I can even foresee. From an economic perspective, even without knowing the additional staffing and computer costs, I can say that some of our most challenging cases are these Wright v. Osborne cases where we are looking at shared custody. We are having to gather both parties' income. We're having to plead both parties' income. We don't have the type of turnout that I imagine you have in family court, so oftentimes we have one party that's not present at these hearings. They are the most time-consuming of all of them. And I can say we are a very voluminous program. As Mr. Watoon noted, Clark County alone has over 50,000 cases. To be able to hear 15 to 20 cases per day, when we start getting into custody and child care and all of these other things on every single case, that means maybe we're not able to hear 20 cases per day. Maybe we're only able to hear 10. That's going to create a backlog. But it also means that family court will have an influx of cases, and that's a whole other perspective. While I appreciate the consideration of the 4D program, when we start getting into timeshare and custody, 4D is not funded for those types of things. So right now, we advise parties to go to family court and obtain an order, and we refer them to mediation at no cost. So if we are litigating timeshare and custodial arrangements on every single case, that's an influx to the private bar, and that's an economic issue that, of course, I'm not able to deal with, but that may mean additional judges, additional hearing masters. So the cost is beyond just the computer. It will impact the private bar as well. And yes, the majority of our cases, we are dealing with timeshare with one party. Mr. Watoon, of course, can weigh in, and he knows more than me, but I would say that at least half of our cases are welfare referred. So oftentimes the child is with one party, and welfare provides funding to that party that they believe is the custodial parent, absent a court order. And in most of our cases, we don't have a court order. We do get into timeshare, child care, all of those things, if both parties agree and if we have a court order. But in most of our cases, that is not the case. Thank you.
Can Ms. Clifford, you clump together custodial time with child care too? Did I hear you right?
We do on every case. In establishment cases and modification cases, we hear child care. We're all guided by the same deviations that are noted in our NRS. So child care, and I think Judge Robb had indicated something about relative income. I will tell you that in our court, that's not used. We so rarely consider relative income in terms of an obligor's spouse, unless they're willfully underemployed. But in any event, that might be where across the board we see inconsistencies north and south. But yes, we consider health care, and we have the same thing as Wisconsin in terms of the 5% cap. All of you know that. But yeah, we do health care, child care, the same deviations that you would see in family court, we do. But custody is an issue that we don't deal with unless both parties agree. What our hearing masters will do is provide a custodial offset. So if an individual comes to court, the obligor, and states that they see the child, you know, we have the 60-40, but let's say it's less than that, so it's not right v. Osborne. Let's say it's 2 days a week, and it's consistent, and mom agrees, so there's no dispute. The hearing masters will provide an offset. So they're not making findings that that's the custodial arrangement, because they're not able to make those sort of custodial determinations or custody arrangements, I'm sorry, but they will provide an offset for timeshare.
Well, I think what caught my attention and where it gets down to this, what is our basis of our support guidelines model, is how the cost of childcare can never be lumped together with the theories of custody. I mean, the one thing I found really enlightening from our first speaker on Minnesota was her just really emphasizing how expensive childcare is, because it really is. I mean, it is outrageous. And we get such a different take from every single judge about how to deal with childcare and how they're going to approach it, because our factor is so vague about it. And the only reason I asked you specifically about it is because I just got curious about how 4D in Clark County was dealing with childcare, because I had an inclination that it was going to be dramatically different from Washoe County dealing with childcare and or a rural county dealing with childcare. But I think it brings me more wholeheartedly back to take our model that we have, not completely flip it on its head, but modify it to deal with these specific situations so that we cover those problems. But I would love input from both from each of the DAs about if we had a specific formula to deal with child care in every single case, is that as much of an obstacle to you as is saying you've got to at least come up with a temporary custody arrangement?
Madam Chair, if I could just go back to the child care issue. Generally, our hearing masters provide they'll provide 1/3 of the cost on top of the child support amount. Again, without any specific guidelines in writing, you can find some inconsistencies, but generally, let's say, for example, the petitioner's cost is $300 a month. The respondent's obligation would increase by 1/3. And the reason it's 1/3 and not 50% of the cost or 1/2 is because the custodial parent benefits from the tax credit every year.
Madam Chair, this is Joe Sanford with the rural DAs. I'd just like to express my opinion that I agree with a lot of what Ms. Cliff expressed, and that in the rural areas, it's very similar to Clark County's as far as how the cases are distributed. Specifically, the majority of our cases, just personal experience from Churchill County, are single parent primary caregiver cases. There are occasionally a Wright versus Osborne case, and even more infrequently that we would do anything that's not an agreed 50-50. It's very rare that someone would say 60-40 or anything like that. So the impact of having to gather income information for both parties is significant, especially since many of the custodial parents in our cases are outside of the jurisdiction in other states that are referred to us, and very infrequently do they even attend the hearings, just because at this time they know that their presence is not necessarily required, but their information is going to be very difficult to track down, and would require a significant amount of work.
Madam Chair, Carrie Lepre-Cordisco for the Washoe County DA's office. I would agree with really both Clark and the rural counties. We still have most single parent cases. However, our court master does do a number of time spent deviations when there is an increase in the non-custodial parent share custodial time, excess visitation. And, I can't say he's consistent in what he does. He really does try to make an effort in balancing it out. We have many serial parenting situations where we have number of A, B, C, D, E cases, which also complicate with, we can't do a flat fee for each child because then there wouldn't be a child support order for the one child. In my opinion, and especially in Washoe County in some of our cases, the addition of the child care costs on top of the child support makes them uncollectible, makes them unpayable. We do try to, Judge Rob requires if we're making a deviation, or in cases I've had with her, when we're making a deviation for child care, I need to have the custodial parent's income in there so that we can determine how much of that child care is reasonable for him to pay or her to pay. If the custodial parent's income is much higher, then the non-custodial parent's is less, usually. But that is one of the biggest issues that we have that causes these absolutely too high orders. We've had cases come in, the parents come in after the hearing and said, I know he can't pay that. We need to stipulate to reduce it. So some sort of a flat rate or percentage for child care, I think, would really help enforcement, or at least the establishment in our cases. Thank you.
All right. I have a realization that we've been going for 3 hours or 4 hours. When did we start? 3 hours ago. So why don't we take a quick break for 5 minutes. We'll reconvene at 3, I can't really see that clock. I'm trying to see it. 3:20. And I believe we can see if we need to take possible action on 8A. I don't know if there is action that needs to be taken, but we will make that determination when we return. And if no action is required, because we had our discussion, we can move on to 8B. All right, team, clock is showing 3:20. Let's reconvene.
Yeah, that's awesome.
All right. Under our agenda item 8A, we are having our discussion regarding items 2 and 3 of Exhibit 44. In looking at items 2 and 3, I wanted to kind of move us along and see, because I'm hearing and feeling some consistency within the commission about perhaps keeping somewhat of the same model, but making adjustments to it to fix some of the other injustices we see within the model, but not completely turning it on its head. Number 2 of the recommendations that we were going to review and assess was review the premise and basis of Nevada Child Support Guidelines model. I believe we've accomplished that. I don't know if there's action required on that, but number 3 is determine whether the base guidelines percentages/formula should be changed. And underneath that, it gives a why and a how. The how is review the economic evidence on child rearing expenditures in this report in sections 2, 3, and 4, and new studies of child rearing expenditures as they become available. That's where we're at, I believe, just to get us kind of focused on where we need to be in the agenda and moving forward. During the break, I also became aware that both Mr. Sanford and Judge Robb need to leave early, and so we still had a quorum before that, whether so it won't affect or impact our quorum at this time. If they want to make any statements before they take off, I want to give them that opportunity to do so right now.
Madam Chair, this is Judge Robb. With regard to agenda item, I believe it was 8A, I would move that we, given what I've heard from everyone who's spoken, I would move that we concentrate our efforts on using the model and the guidelines that we currently have in effect and use our efforts to modify that model so that it is fairer and better serves the citizens that we are trying to serve. But we use that model as our jumping off point.
We have a motion. Do we have a second?
This is
Judge
Hoskin.
Sanford,
I'm
I'd
happy to
second.
second that.
Okay, any discussion? All in favor, say aye.
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 Aye. Aye.
Anyone opposed? Motion passes. Based on that motion and action, I believe that moves us to our next agenda item, which would be agenda item 8B.
And Madam Chairwoman, Judge Robb again, I do need to leave, but I'm giving you my proxy. I was informed at our last meeting that that was appropriate, so.
Thank you. Agenda item 8B is discussion and recommendations as to whether to eliminate the presumptive maximum amounts and whether to replace them with a formula and provision consistent with economic theory and the economic data on child rearing expenditures. This was specifically item number 5 of Exhibit 44 within the guideline review. Do we have discussion on that?
This is Ellen Criselius. I pulled the more recent USDA report on child rearing expenditures, and in the Jane Venor report, the USDA amount was $9,950. The newest amount is $12,350, so it's increased significantly since the last report.
It's Judge Hoskin. I think I made this clear at the last meeting. I think that we do need to make some adjustments to the fact that we do have a cap and we max it out and don't go any further. I'm not of the opinion that the percentage goes on forever. I think there needs to be some adjustment as we go higher, as some of the other states have done. But I do think we need to seriously consider eliminating that maximum amount that we have currently in statute.
In addition to that very top maximum amount, I think just having the income brackets has been a big part of the problem, and actually what the expert who did the guideline review was also referencing that she did not particularly like about Nevada's formulas. I think the income brackets, the presumptive maximum brackets, is what causes a lot of the injustices, because percentages change so much as you move from bracket to bracket and is inconsistent as you move down the line. I would be, according to this one, number 5 of Exhibit 44, I'm inclined to say dump those maximum amounts and develop, as she states in here, develop a tax-like table of percentages or schedule to address not just the higher income, but to extend the presumptive formulas to incomes where the economic evidence of child rearing expenditure is reliable, and provide that for incomes above this income, the highest amount of is a presumptive floor rather than a presumptive cap. I think when I look at some of these other models that were presented to us and looking at Wisconsin, this seems to make sense. Those brackets of income is not something that we're seeing amongst other states. Other comments on this?
Keith Pickard for the record. I agree. I like the idea of tables because they are easily used. They can be amended fairly easily. And I like what I saw. I believe it was Wisconsin's where they went up to 25,000. That may have been North Dakota's, I don't recall. But in any event, I think we can address some of the inequalities and make it easy for the practitioners if we were to adopt a table. And also, as I was looking at those numbers, we saw the elements of the economic theory where we saw the amounts as a percentage of income decreasing as income went up. And certainly if we're at a 25,000 per month income level, particularly if we do it on a combined income level, or I'm sorry, on an individual income level, I think that the additional expenditures to address the economic theory drop to probably nil. So I don't have a personal problem with having an absolute cap at some point. It just needs to be a whole lot higher than it is now.
My response to that, or comments on the record for that, would be that our agenda item and Exhibit 44, what number 5 is asking us to do is really just look at if we're going to eliminate it, and the good news is, as a committee, once we make that decision, how to eliminate it is still left to be done, and what it will be, or what those calculations will be, or how that table will look like, we don't have to do today, which I think is probably the more important. We're looking at the big policy picture here. And the way they have number 5 set out for us in this report, or what we've developed as our agenda item, is just really looking at, we're going to replace them, but we didn't necessarily say we had to come up with a solution about what it was going to be replaced with. Anyone else? More comments?
Madam Chair, are you looking for a motion on that?
Sure, I'll take a motion. I was seeing if we had any more input first, but let's take a motion.
It was dead air for a minute, so I thought I would jump in. I'm happy to move that we eliminate the presumptive maximum caps as we have them currently, with the anticipation of exploring how to deal with those high-end cases at a future meeting.
I'll second it.
Any discussion? All in favor, say aye.
Aye. Aye.
Aye.
Anyone opposed? Motion passes. All right, we will move on to agenda number 8C, discussion regarding the appropriateness of the minimum order and recommendation as to whether to make changes if necessary, and also discussion and recommendation of whether Nevada should develop a self-support reserve or low-income adjustment like those used by other states. This is specific to items numbers 6 and 7 within Exhibit 44 of the Guideline Review. And if we look at that, number 6 specifically states, well, let's start with 6. Let's break it apart. Whether we should develop a self-support reserve or low-income adjustment like those used by other states. My comments, and then I'll move on to other comments, is that I don't see how we cannot. I think the review, one of probably the largest critiques we've had within the review was the fact that our $100 minimum in many scenarios with extremely low-income individuals is very much so unrealistic and not practical. I also think that some of the testimony and reports that we received today from the other states, that was one of the specific things they were also dealing with. Mr. Fleming made the comment that that was one of the adjustments they were making also. Of course, in their adjustment was anything under income of $760. I think, again, we don't have to know, based on this agenda item, what we're going to set it at as much as are we going to do it. And it kind of automatically sets a future agenda item for figuring out the amount or how to calculate it. But my opinion would be that we develop a self-support reserve or low-income adjustment that is not the $100 minimum per child that we have currently in Nevada statutes. Other comments or input? Dead air, does somebody want to make a motion based on dead air?
Based on the dead air, Madam Chair, I'll go ahead and make a motion that we develop a self-support reserve or low-income adjustment as part of these discussions.
Madam Chair,
Yes?
I second that motion.
Okay, thank you. Any comments? All in favor, say aye.
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 If opposed, say nay. Motion passes. Number 7, which is still under agenda item number 8C, but number 7 of Exhibit 44 was specifically review the appropriateness of the minimum order and make changes if necessary. I think we may have just made our motion that complies with that unless anybody has additional comments that believe we need additional action for number 7. All right, hearing none, I believe we've appropriately dealt with that agenda item.
Madam Chair, I
Yes?
think for, if I may, just for clarity's sake, let's go ahead and, if I can move to eliminate the minimum order as part of the discussion in developing a self-support reserve.
Do we have a second?
I might just have
Second.
some comment on that, actually, in that
Okay, first off, do we have a second? Then we'll do discussion on the motion.
Yeah, Judge Hoskin, I seconded it.
Okay, go ahead, Mr. Samhart.
I completely agree with the self-support reserve, and I think that may address a lot of the issues regarding a minimum order. But I believe there is still some need for a minimum order of some kind. Otherwise, we may end up with many cases of $10 or $12 in the order. Anyway, just a number of other states had some minimum order, even if there is a self-support reserve. So I just think it bears more discussion or determination as to whether a minimum order of any kind is important, even if there is a self-support reserve.
This is Dawn Throne for the record. I would point the committee to the Exhibit 37 on page 55, Not necessarily that we like the exact numbers, but it's an approach to the 100 per month per child becomes onerous when they have multiple children they're supporting, and this still makes sure, even though they're low-income obligors, that they're still providing some support that's reasonable within their income.
Madam Chair, this is Karen Cliff from the Clark County District Attorney's Office.
Yes, ma'am.
I do agree with addressing and having possibly a self-support reserve and some sort of low-income adjustment. However, in terms of eliminating a statutory minimum, I think maybe that the process of how we do that, in my mind, still needs to be explored. And perhaps one of the ways that we create a self-support reserve and address low-income obligors is to eliminate the statutory minimum, but I'm not prepared at this time, to agree with removing the minimum order.
Madam Chair, if I may, I think at least where I was going was, as we're developing a self-support reserve, one of the things we want to do from a compliance issue is reducing the number of deviations that we see. Many of those, I think, probably, and I don't work in the 4D program, so I don't know how it would affect there, but as we look at the deviations, if we maintain a minimum, regardless of what the circumstances are, it's going to naturally demand a certain number of deviations. Instead, my thought was that we could incorporate what a minimum amount would be under the self-support reserve. Thank you. As it was described by Mr. Fleming, where they have a zero line at 700 and below for income in terms of the amount paid. And then that just eliminates deviations. Now, if the committee wants to go a different direction, I have no particular dog in the fight. I'm not beholden to the utter elimination, but I think in terms of the compliance, elimination makes some sense as long as we incorporate something into the self-support reserve mechanism.
Do we have any more comments? I'd like to point the committee to right before that table that was pointed out on page 55. If you look at page 53 and 54, that is the discussion right at the bottom of 53, discussion and recommendation specific to the minimum orders given to us by the review of our child support guidelines. Obviously, the reason for this commission is that we don't have to go through and do what the recommendations are. But if that helps at all with this discussion, in keeping a minimum order amount in addition to this the self-support reserve, just point it out right now for the purposes of this discussion to see if it aids at all in anybody's opinion.
Madam Chair, maybe I can clarify. At least my understanding was the motion is to eliminate the minimum order as it currently exists, with review to go back and see where we want to go from there. I didn't understand, and maybe Mr. Pickard can clarify. I didn't understand that we were saying we'll never have a minimum order. We're just eliminating the way that it currently exists to move forward. So maybe some clarification would be appropriate.
And I think that, this is Keith Pickard for the record, that's exactly what I had in mind.
So state it again. I'm
Madam
not sure
Chair,
I'm following either.
Well, maybe I would amend the motion simply to say that to the extent that we believe that the minimum orders as it currently exists in statute be eliminated with the idea that we're going to be developing a more appropriate mechanism for assuring a minimum child support amount under the circumstances given with respect to the self-support reserve. I think rather than clarify it, I'd probably just made it more complex, more opaque. But in any event, if someone wants to restate it more clearly, I'm happy to use that language for an amended motion. Ultimately, I just want to get to a point where I think we're all in agreement that the $100 minimum is inappropriate and unworkable and leads to an absurd result, particularly in those cases where we have substantially no income to speak of. In those cases, I think it should be eliminated. So to the extent that the existing statute doesn't apply, my motion is to eliminate it as currently written, or that we should craft the rules so that the minimum standards as currently written are modified in a way that comports with item number 6 of the report of Exhibit 44, the self-support reserve.
And Ms. Chair, this is Karen Cliff from the Clark County District Attorney's Office. With the amended motion as it stands, just for me personally, I would be fine with that. On page 53 of the report, it does state that the majority of states that have a self-support reserve do have a minimum order. The report indicates that there's only 2 states that have a self-support reserve but do not retain a minimum order, and that's Arizona and Pennsylvania. So I definitely think that there's a mechanism in place where we can still maintain a minimum order, but of course look at what happens when the obligor has multiple children. So that would be my position, that we explore possibly making changes to the way our minimum order reads now, but not necessarily removing the minimum order. Thanks.
Based on the amended motion, do we have a second on the amended motion?
Well, I would typically second it, and I'm still not sure that I understand it, and I did tell Mr. Pickard that. Are you willing to withdraw the motion and I'll restate it?
I'll withdraw the motion.
Okay. The motion the motion I'm going to put forward is that we agree to eliminate the $100 statutory minimum that currently exists with the anticipation of reviewing in conjunction with number 6 the best way to approach this issue as we finally resolve it.
I'll second that.
All in favor say aye.
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 Opposed? Motion passes. The follow-up on that agenda item that I want to throw out there is that based on the amount of work that we have to conduct in this commission, as those specific items like that come up, at some point we have to make the decision. So obviously the minimum amount's still going to be on our agenda, on a future agenda, for us to readdress and still circle that same wagon. But I think conceptually, we've come to some big decisions today as to how we're going to move forward with Nevada. Just throwing it out there that the work will come. We can't push it off forever. And it's going to come back to haunt us. So with that, I believe we are done with agenda item number 8C, which brings us to agenda item number 9, which is future agenda items. Which brings me to that last comment of saying, do we, at the very next meeting, want to deal with figuring out that calculation, since it's fresh on the mind and we've all just been sitting here contemplating minimum support orders, and jump right into it or not?
Just, Judge Hoskin, at least the way my mind works, I need to conceptually look at it from 30,000 feet before I can drill down on it. And I'm not sure that we have that 30,000-foot view just yet. But that's just the way that I think about it, so that's my own opinion.
Okay, then my next thought or comment about that, to develop agenda items, it would be that we move on to some of these other big conceptual ideas that are listed in Exhibit 44 for our next agenda items, so that we can come up with the baseline of where we're going, and then we can continue narrowing it down. So we ticked off today, off of Exhibit 44, we've done 1 through 3, we've done number 5, 6, and 7, leaving us with number 4, 8 through 16 as options to deal with next. And once we kind of know which of these we want to deal with next, it also assists us in determining whether or not we're going to have additional experts come in with reports to help us with any of these items for the next agenda. Thoughts on where to go from here, or do you just need a second to read it? I'm assuming that might be more appropriate.
Madam Chair, just a quick question. Do we have a budget for experts?
Do not believe, no. We have a little bit of budget for travel, and that's all we've got. As the legislator, you didn't get us a budget for it.
Elections have consequences, and I was in the minority.
So no, not those kind of experts, although I think what we saw today is pretty fair representation, that people are pretty excited to contribute their opinions, especially when it's just by phone and we're not having to fly them in or have any expense to them. So I don't think it'd be too hard when it's a specific issue. The only time it could cost us some money, or I foresee it being a problem, is if we had to reach out to the individual that did this review for us. She was under contract, and so that would be a cost issue. She might give us a little bit of flexibility and help us out a little bit, just from my experience with her, but that's not a guarantee. She was on an hourly contract to do this work, so.
And Madam Chair, Keith Pickard again for the record. I was just speaking as to number 4 specifically. If we're going to be trying to gather private case file data, that would probably be a team of people in order to get to sample sizes large enough that it would actually aid us in making any determination. So from a practical standpoint, I'm thinking number 4 may not be achievable. I recognize that means we have to kind of work in a vacuum, or at least in some gray area. We all have anecdotal, or many of us have anecdotal experience. But I don't know how we go about getting additional case file data without hiring some people to do the research.
My opinion on that item is that this commission is going to continue to live on. And every 4 years, we're going to have one of these guideline reviews. And I see this commission as having a duty to determine for the next review how to approach it, because when that review gets put in place, she's going to be asking for that data again. And so I see number 4 as being the literal last thing this commission deals with. A report on changes to the guidelines would happen first, because number 4 doesn't really impact anything until the next guideline review. Because we're not going to go redo this review based on any new data. That's not going to happen. So, but I see us finishing the report. Our commission doesn't just break apart. It stays intact. It doesn't have to meet as often, thank goodness, after that. But it'll be an ongoing issue for this commission to know how it's going to get decent reviews back for future changes.
Well, and maybe we can then impose upon Assemblyman Fumo in the next legislative session to bring a bill to fund that research.
Madam Chair, in looking at 8 through 16, it appears to me that 8 and 9 would probably need some discussion at a further, because I think they're kind of separate. 10 through 14 are essentially deviation factors, and I think that once we get our formulas put together, then we'll have a better idea of how we want to deal with those deviation factors. So my suggestion was we kind of lump those together, but we may be premature on those. And then 15 and 16 I would lump in the same category as 8 and 9 and that we kind of need to deal with him on a separate basis. So if you're looking for suggestions for moving forward, I think we probably need 8 and 9 and maybe 15 and 16 on the next agenda, along with maybe narrowing down what we want to do in modifying the support obligation, or the support guidelines, I should say, and then leave 10 through 14 for a future meeting once we're a little clearer on what we're doing with the formulas before we start dealing with deviations.
Madam Chair, I'm talking too much, but I'll just add that I agree completely. I think that makes a lot of sense, what Judge Hoskin just suggested. I would probably suggest, though, that we have a specific line item in addition to these to talk about the formula itself, whether or not, going back to the question of do we want to make any changes to the essentially the action items, the determination items under 4, 5, and 6, or rather 5 and 6. What does the underlying or base calculation look like? We need to actually put some flesh on those bones before we can address the outliers, the separate questions.
Yeah, I think my input would be that I feel like almost our entire agenda today still needs to be revisited before some of these other matters in this list. Because now when I look at it specifically, I mean, 10 through 14 will have an impact based on, well, a lot of it, just looking at the Wisconsin stuff, we've got some good materials to go off of, in my personal opinion, to borrow from. But dealing with incarcerated parents, the federal rules are pretty specific. Not pretty specific, they're specific. And it's an easy agenda item for next time. I think we should put number 8 on the agenda no matter what. We can knock it out, get it done. Number 9 is it's more conceptual, which I think will help us in formulating what we've already talked about today. And I don't think 15 hurts either, because I think it also sets some of our concepts and the policy that we're chasing after and making the other decisions. 16 seems vague to me. I'm not real sure what we're supposed to accomplish under that, because we've done that. That was kind of what we did for our after our first meeting, is send everybody home to do the homework and read the federal ruling. Other thoughts on how to, I would like some thought on how to readdress what we did today that we left in the open air about, that we need to still accomplish.
Madam Chair, I feel like Keith Pickard, because I seem to be talking a lot. I think we need to start narrowing down, and I think that's what you're asking us to do at this point. And perhaps we can, between now and the next meeting, we can come prepared to discuss what we're going to do with the percentages, if we're making changes to the percentages, if the percentages change at a certain income level, if we're going to use tax structures to make that happen. But I think if you can task us with that between now and then, and we can discuss it at the next meeting, essentially duplicating what we have in 8A and 8B and 8C for the next agenda, to add, and then to add perhaps 8 and 15 in addition to that, then I think that'll probably help us to narrow down. My hope is that by the end of the next meeting, we have a really good framework of what the guideline's going to look like, and then we can deal with the periphery items following that meeting, is my suggestion.
What he said.
Duplicate what we had in the agenda today, with everybody being tasked to come up with specific conclusions for that. And then I want to make sure I followed you right. You said, and then also add to the agenda number 8, correct? About incarcerated parents?
Yeah, 8 sorry, I'm going agenda and then back to exhibit 44. So,
8 from the exhibit, and then also 15 from the exhibit.
Yes, that's my suggestion.
I would agree with
And I
that.
think you, as the chair, can do whatever you want, from what I heard this morning. So
I heard that
too.
Weird. That's stuck in my mind. But whether I can do anything I want or not, I want to make sure we all come back prepared so that we can actually do it. We made some big policy decisions today, which is great. But when we narrow it down to 8A, B, and C on our agenda today, we made some big decisions on sticking with our model and making changes to it, which requires us all to take a look at the states that were presented today and the states that in the review were given to us as models to make some decisions on what to use or how to move forward with it. And we'll go ahead and ignore the other exhibit items for now, because I think you're right, we've got to come up with those decisions. I think that creates a pretty good future agenda items for us. Does anybody have any other input on something they would like added to the agenda next time, or somebody you would specifically like to hear from next time that we may be able to line up?
Madam Chair, just a question for clarification. I understand we all agreed to keep our model as it is with some tweaks. Are we also referring to keeping the percentage model as it stands in terms of the 18, 25, et cetera? Or is that up for discussion at the next meeting as well?
It's my opinion it's up for discussion.
Okay,
that
thank you for
we're keeping the broad model of not moving to an income share, but that tweaks to the model that we have are all justifiable and still on the table. And probably necessary, quite honestly. Okay, hearing no other future agenda items or comments based on our agenda item number 9, we're going to move on to agenda item number 10, which is approve future meeting dates. I'm just going to put out there we will do exactly what we've done in the past. We will send an email. I'm going to aim again for about 3 weeks for us to reconvene, 2 to 3 weeks. And we will send an email out, and whatever the majority number of members we can get to the meeting, we'll pick that date and go with it. I think this time with the teleconferencing went better than it did the first meeting. And that may be just a matter of which hearing rooms we used. I don't know. We had more assistants today in this hearing room, so maybe if we can keep that in mind, if they can keep us a little more consistent. Anybody have a problem with that being the method in which we set the next date? Or any comments on that? I don't think we need any action on it. The last agenda item we have today is, once again, public comment. Public comment will be limited to 3 minutes per person. Do we have anybody in Las Vegas that would like to give public comment?
No one here, Madam Chair.
All right. Anybody in Carson City that would like to give public comment? We have nobody here to give public comment. I will entertain a motion for adjournment.
So moved.
Second?
Second.
All in favor?
Aye.
Thank you,
Aye.
everybody. Have a good night. Appreciate your time.